All right, folks, I'd like to call the first and a half Courts of Justice meeting to order. We'll quick call the roll.
Mr. Chair, you have a quorum.
Great. Thank you, Michael. Well, everybody, welcome to the very first Courts of Justice meeting for 2024 session. I want to give everybody a chance to introduce themselves and our staff working with us, and then we have a president, we have to do judicial certifications, state police presentation. We're going to get into the bills. We also have a bunch of bills going by for the day. So my name's Scott Survell. I'm the new chairman of the Courts of Justice Committee. I represent the 34th Senate District, which is Eastern Fairfax County, and why don't we go down this way to our former chair and beyond. The button there. There you go.
I'm Creed Deeds from Charlottesville, represent the 11th District.
Hi there, I'm Senator Jennifer Boysko, representing the 38th District.
Lamont Begbie, I don't remember my district number, Richmond and Henrico, 14.
Good morning, LaSharice Aird, Senate District 13.
Good morning, Suhas Subramanian, representing the 32nd District.
Good morning, Jennifer Carroll Foy, representing the 33rd State Senate District.
My mic isn't turning on. Now it is. Ressa Perry, representing the 31st Senate District up in Loudoun, Buckhead County.
I'm going to do it like football.
Good morning, Saddam Salim, representing Senate District 37th.
Mark Obenchain from Rockingham, representing the 2nd Senate District.
Richard Stewart, representing the 25th Senate District.
Hammond City College.
I don't believe that he really played fullback. I'm not even positive he went to college. Mark Peak, Senate District 8 from Lynchburg.
Emily Jordan, 17th Senate District, representing Suffolk, Franklin, Isle White, Southampton, Greensville, Brunswick, Dinwiddie, and Emporia in the city of Portsmouth.
Awesome, and welcome to all of our new committee members. We had a lot of new faces on the Courts of Justice Committee this year, along with our new name. Counsel, why don't you guys introduce yourself to everybody, the people that give us our legal advice.
I'm Steve Benjamin. I'm counsel to the committee.
I'm Taylor May, and I'm an attorney with Legislative Services, and I'll be handling the criminal-related legislation.
I'm Sabrina Miller-Bryson. I'm also an attorney with Legislative Services, and will be handling all of the civil legislation.
Okay, now our committee staff that keeps things moving and keeps the cameras on.
Michael Jackson, I'm with the Senate Clerk's Office.
I'm Ashley Heinz with the Senate Clerk's Office.
Shannon, you do things too.
Shannon Hurd with Legislative Services. I'm the Judicial Selection Administrator.
Great, awesome. And I guess we don't have our pages here yet, do we? We'll get them. We'll get them when they get here. Okay, great. Well, welcome everybody to our first committee meeting. First on the docket, we have judicial. Actually, why don't we do judicial certifications? So everybody should have been given. I think there's a list. Is that right? Yeah. These right here. There should be a list in front of you of all the judges that we need to certify, just so the public's aware. Everybody on this list was interviewed in public jointly with the House of Delegates, Courts of Justice Committee back in early December. And under our rules, they have somebody has to be certified and by our committee is qualified before they're allowed to go on the floor for a judicial election, which will probably be later this week. The committee typically takes these names up in a block and will operate by voice vote. If somebody wants to remove a name from the block, you need to do so at this time. So does anybody have any names they'd like to remove from the block? None. Okay, so the chair will now entertain a motion to certify the incumbent judges and candidates qualified for their respective judgeships as listed. Is there moved?
Second.
Okay, it's been moved and seconded that we certify the names that are in front of you. All those in favor say aye. Aye. Anybody opposed? Okay, unanimous, Michael. Thank you. Okay, next on the calendar we have presentation from Virginia State Police, which is carried over from what the hearing we had last week on Wednesday to talk to us about expungement and sealing. Lieutenant, right? Captain. Okay, Captain Rogers, you want to come on up and talk to us? So, folks, what this is about is in 2021, we passed legislation authorizing a new conviction sealing process and a sort of revamp of the expungement process. We also authorized, I think, about $25 million to rebuild our entire criminal justice background infrastructure, and all that's scheduled to go live next year. It took 4 years to implement. We want to hear what's going on so people know what's coming.
All right, sir. Waiting for my presentation to come up, Senator. It's on the... Well, in the meantime, first of all, Mr. Chair, members of the committee, I'd like to thank you all for having us here today and give us an opportunity to either update...
You might get close to that mic so everybody can hear you on the screen. And...
Okay. Apologize. I'd like to thank you all for giving us the opportunity to update and or introduce each of the members of the committee to this project. What we're doing really is, if you look at this in a co-project, we're replacing somewhere between 60 and 75% of some of the most complicated computer systems within the department. To that end, I would like to take just a second and introduce Lieutenant Julia Gunderson. Lieutenant Gunderson actually relieved me in CJIS, and although I still maintain responsibility for the implementation of the project, when it's completed, it'll be her personnel that actually operate the systems day to day. And so we work together on a regular basis. Thank you. All right, so Project CHRIS. CHRIS is an acronym, Criminal and Rat-Back Information Systems. We are replacing 5 systems and introducing just a little system that there's been tremendous interest in called Rat-Back into the Commonwealth for the first time. And I'll unpack those just a little bit later. For today, because of the size and scope of this project, again, 60 to 75% of state police systems being replaced almost near simultaneous. The state police has had disparate processes. You know, our software, our systems, our processes. As we've grown up over time, hey, we have a new assignment from the General Assembly. Well, let's implement it here. What Project CHRIS really represents is an opportunity for the Department of State Police to reimagine, to bring into alignment how we do business from start to finish, and really make sure that we're getting the maximum efficiency and value and leveraging the new technology for the citizens of this Commonwealth, and to make sure that we get it right. So, Senator Servell, big milestones along the way. In 2021, we got the bill. A lot of people refer to it as sealing and expungement, but again, it directed us to purchase all these systems, not just sealing and expungement. And so to that end, our criminal history system, the background check system, a new search engine for the Commonwealth, the Rat-Back system, the civil commitment system, the system that keeps people from having guns that are not legally entitled to them, all those being replaced under one umbrella. Criminal and Rat-Back systems, Project CHRIS, and it all started right here in 2021 with this legislative mandate.
Senator Peake, you got a question?
Tell us what the Rat-Back is.
Okay.
What does Rat-Back system mean?
Happy to. Mr. Chairman, Senator Peake, Rat-Back. What Rat-Back will let us do for the first time. Today, if we were to do a background check for you, it would be a snapshot in time. It would be current in time, as of this moment. If we run my criminal history right now at 8:10 in the morning, it's accurate when we provide that response to, say, the Board of Nursing. We provide it to a school system. If I go out and it's 8:01 and get arrested, That criminal history is no longer accurate, but there's not a present mechanism to update that school system or that nursing board. What RATBAC will do, very specifically, it will allow governmental entities to enroll their personnel in this RATBAC system. Once you're enrolled in that RATBAC system, now we have monitoring. And so if I got arrested at 8/11 and there's RATBAC in place, now when that arrest hits the FBI will send a notification to the Department of State Police. The Department of State Police will be reaching out to the government entity that enrolled that person, saying, do you still hold this interest in this person? In other words, is it proper for us to release this information to you still? And once that entity has confirmed that they still hold that interest, we will then release that updated information to them, not in real time, but certainly not with months or years of delay.
Captain, so basically if you get a DUI and your employer had you background checked for your job via the Virginia State Police, you get a DUI, your employer's going to know the next morning you got arrested.
Yes, sir. Yes, Senator. We will make those notifications that quick.
It's a big change.
Our goal right now internally for discussion is 6 hours or less. So the other thing that the legislation originally did in 2021, it gave us a legislative mandate of July 1, 2025 to be prepared to go with these new systems. In 2023, there were some refinements to the original legislation. Senator Survell recognized that something had occurred in the original legislation. The word expungement was used, and the pieces of the legislation were placed in the expungement section, but unfortunately the process that was described was perfectly silly. And that caused great confusion and angst on our part because, we're using a word expungement that has a specific meaning to the department. It's in a different part of the bill, describes a different process. We weren't really clear because they do have different outcomes. With expungement, we completely remove your record. Did this happen? No. With sealing, by contrast, an agency that has the authority, the legislative authority to view the record, we still will respond with the record if you have the right legislative authority. So that caused us some angst because we had different terms, didn't really know what to do with it. That was fixed for us in 2023. And then, of course, we had additional language come out of 2023 where Senator Reeves was good enough to carry a bill for the department, and it brought us much closer to the language that we needed for the FBI to allow us to operate the RATBAC system. Unfortunately, there was one small piece that the FBI found that did not meet their standards, and we are this year going to be asking for a redo on that piece of it. So, Chris, it's absolutely state-of-the-art. Virginia is going to be at the forefront of our field, right where we were at one time. And here's your different systems. Replacing the computerized criminal history system, this is the system that records arrests and dispositions for the entire Commonwealth. Our present system can't even comply with national standards. It literally would cost more to program it to do it than it did to replace it at this point in its life cycle. The civil commitment module, again, this is what we rely on to make sure that people that are disqualified from having firearms can purchase those firearms from a mental health perspective. The expunge and seal module, the master name index, this is a search engine. Again, this particular system is key to the department because it feeds all of our other systems. The applicant tracking system, that's where actually the background checks do occur. That usually generates tremendous interest from the standpoint of governmental employees, teachers, healthcare employees, people that have care for children, disabled, elderly, and then, of course, RATBAC coming in. Since we were given the legislation, it was signed on April 7th, 2021. This is one of those parts when I want to take just a second. And if there's anyone that ever wants to talk about the efficiency of state government, will never be able to thank the people at VITA and OAG enough for what we were able to do with Project Chris. Recognizing our timeline, and I will name names in some cases, we negotiated a high-risk contract inside of 5 months. VITA gave us priority, And we were able to work with them to get this through their full regulatory process. And that has made all the difference in the status of this project instead of an 18 to 24-month negotiation period. We'll never be able to give these people enough credit. So today, Block 6 there looks small. We're building. We are actually programming, having meetings, and, like any project of this size and scope, we certainly have our challenges, but we are very happy with where we are today. And so with that being said, we do have a couple challenges ahead of us. We really do, or could. This is a very complex interaction. Our criminal history system touches so many different state agencies, and just having to work out the requirements to keep each of those exchanges online, get them implemented, very difficult. It may be safe to say that there's no department right now more scared when the legislature meets than the Department of State Police. Any legislation that requires development, if any legislation is passed that requires development in our current system, well, we have to develop it in the current system, and we would have to develop it in the system that's due July 1, 2025. If that were to occur, it would bring a challenge on the table for us to still meet that legislative deadline, just because those same resources would now have to work on two projects. And again, very large, very difficult project. And of course, you get into a project of this size and scope, we have a plethora of IT challenges. The complexities involved in this, getting the identity approvals and verifications correct for everybody, the data quality. And when I talk about data quality, every agency in this state so far has data needs of their own, and they keep data in their own way. There's never been a collective among how the Commonwealth agencies would get data. So the individual programming presents unique challenges. And then, of course, just getting those interfaces right so that the data will flow seamlessly between the different agencies. And so what is our timeline? We started, of course, when the governor signed the legislation. We'd already laid the groundwork. We are presently doing project work, and this is certainly subject to change. I will tell no one in this committee, just given the difficulties we have, that it won't be July 1, 2025, but as of today, we think we're going to deliver certainly within that second quarter of 2025, and we're hoping for the first part of it. And so with that being said, I'm more than happy to answer any questions I can answer for the committee.
Thank you, Captain. Anybody on the committee have any questions for this? It's obviously a big change and something we need to take into account as we consider expungement or sealing legislation this session and also next year. No questions? Okay. Captain, appreciate that. There's 1.6 million Virginians that are waiting for this to go live, and I know the Supreme Court, the clerks, the Commonwealth attorneys are all asking us for money to help comply with this, and you all have done a lot of work to get this to where it is, and 3 years is a long time for a project, so we appreciate your work.
Thank you,
That was very informative. Thank you. Great, thanks. Okay, so now we go on to our bills. So first of all, we have 5 bills that are going by for the day. Patrons have called me and asked to take these by for the day. What's the sign up here? Okay, thank you. So Senate Bill 52, McDougall, Senate Bill 207, Senator Diggs, Senate Bill 223, Senator McGuire, can't be here this morning, Senate Bill 236, Senator Hashmi, Senate Bill 602, which is Senator McGuire as well. Is there a motion that we take those by for the day?
Can you say them a little slower? So moved.
Oh, sorry. Okay, it's been moved and seconded. I'll say it one more time. So this is 52, 207, 223, 236, and 602. Did I miss one? Huh? Got it. Okay. It's been moved and seconded. Those bills go by for the day. All those in favor say aye. Aye. Anybody opposed? Okay, these bills go by for the day. There's also 2 bills that were put on the docket to be re-referred to finance because they don't really have much of a policy impact on our committee. They're one is Senator Salim's line of duty bill, which is Senate Bill 649. The other one is Senate Bill 466, Senator Obenshain, which has to do with private police retirement, which we also, it's also line of duty? Okay, line of duty. And we took that to send it to finance last year as well. Is there a motion that those two bills be re-referred to finance? It's been
Second.
moved and seconded. What? Oh, we have to record the vote. Okay, has to be recorded. Please indicate your vote on the voting board.
Ayes 15, no zero.
Great, thank you. Now, we go to our non-committee patrons. First on my list is Senator Eben. Senator Eben, which bill do you have?
Got Senate Bill 369, which is dealing with companion animals.
Hold on one second, Senator. Hold on. Huh? Oh, we didn't do it as a block. We got to vote again. Sorry. Can you open the roll?
Ayes 15, no zero.
Great. Okay, Senator Eben, you're up. We're going to talk about companion animals.
Yes, Senate Bill 369, there's a substitute.
Move to adopt the substitute.
Second.
It's been moved and seconded. We adopt the substitute. All those in favor say aye. Aye. Anybody opposed? Great. Substitute is before you.
Just to explain the differences for those that have been looked at the original bill, the substitute includes the option to for prosecutors to press for lower charges if deemed appropriate. And I do notice one typo in this substitute on line 16. I think you want a line amendment on 16 where it says if any person do any of the foregoing acts. I think it means does. So I would ask that the committee change the word do on line 16 to does.
I like do.
Either way, I think the meaning will be clear. I
It's
just
been
assume
moved.
that's
Is there a second? Okay, it's moved and seconded that we change do to does. All those in favor say aye. Anybody opposed?
No.
Okay.
Okay, so the bill before you would make it a Class 5 felony to deliberately harm a companion animal. Currently in Virginia law, it's only a felony if a companion animal either dies or has to be euthanized as a result of its injuries from trapping or poisoning. This bill would align with the penalty for harming livestock. And according to the FBI, Virginia ranks in the top 5 in several animal abuse categories. We're 4th in the nation for animal cruelty offenses over a 10-year period, 3rd in the nation for the number of animal cruelty offenses in 2021, the most current year available, and also 5th highest in the nation in per capita animal cruelty offenses in 2021. So as I said, under current law, harming a companion animal only results in a felony if the animal dies or has to be euthanized as a result of its injuries, and this would just align it, companion animals with the same penalty for harming livestock. And while companion animals may not bring the monetary support that livestock do, anyone with a pet knows they're very much a member of the family. This bill was prompted by 2 incidents in Alexandria. In February of last year, there was an incident with an individual throwing poisoned meat over their neighbor's fence because the neighbor's dog was barking continuously. And no dogs were hurt since the dog's owner saw footage of her neighbor throwing the poison over the fence. So the individual responsible was charged with a misdemeanor since no pets were actually killed. And in July, in an unsolved incident, someone left 9 pieces of sausage embedded with fish hooks on the sidewalk on Duke Street, and 1 dog was taken to the animal hospital as a result of trying to eat the sausages with the hooks in them. It's a felony to harm or torture a companion animal in 19 states, including our neighbors of North Carolina and Maryland. And I think that we have someone from maybe 2 people who wanted to just say a brief word of support, if they might.
Sorry, does anybody have any questions for Senator Eben about whether we should treat dogs and cats the same as cows and pigs and chickens?
Mr. Chair,
Okay, Senator Boysko.
question for the patron.
Go ahead.
Would this be adding a felony charge to the individual?
Yeah, this would allow for the felony. Right now, it's a felony if the animal dies. This would say if you have the malicious intent, but the animal doesn't actually die because you intercept the poison or the animal just doesn't die, it would allow for a felony to be charged. But it would allow prosecutors to charge with a Class 1 misdemeanor if they wanted to, rather than the felony.
Mr. Chair.
Senator Boysko.
can you clarify if currently it would be a felony for livestock, for malicious? And you're saying cats and dogs?
Yeah, current law says that if you expose poison with the intent to be taken by horse, mule, pony, cattle, swine, or other livestock, it's a Class 5 felony. This would add it to companion animals, even if the companion animal doesn't die as a result.
Great. Senator Evan, any other questions for Senator Evan?
Mr. Chairman.
Okay, Senator McDougal.
Mr. Chairman, the question I have is about fowl. So if you have Canadian geese get onto your property where you sprayed a pesticide and they die or get injured, what happens there?
It would have to be unlawful, or not, I'm sorry, not. I think it says with malicious. I believe it says. Counsel, maybe help me with. I thought it was with malice or malicious intent.
It is, Mr. Chairman, line 11. If any person maliciously.
So if you were just putting pesticide on your lawn and there's an accident where someone ingests the pesticide, I don't think they would be guilty of a crime. Counsel can correct me if I'm wrong.
Again, I don't think that scenario is what Senator McDougal was asking about. It seems to me what he's asking about is if you want to try to get rid of Canada geese on your golf course or your property, that the way this is worded right now, that would become a felony. Am I reading that right? It seems to me the way you might fix that is if we strike the comma after foul, so that the words of another would apply to the foul. So it would have to be a foul that somebody owns as opposed to a foul.
Mr. Chairman, we've spent most of the weekend on this very bill.
I'm sorry.
And one of us wanted to make sure that we could kill nuisance fowl. And we debated the different consequences of this new language. We do agree that of another is meant to modify all of the animals that are listed here.
Okay.
And we have moved the comma all over the place and have worked out a way that we think we can do this.
Okay. Senator Stewart.
Thank you, Mr. Chairman. To Steve or somebody, was foul originally part of this bill, or did we add foul in here?
Foul, Mr. Chairman, is in the existing statute. You would see it on, I think, line
17.
17, that's right. This also gave us some angst over the weekend because foul isn't otherwise used in the code. You have poultry, which is defined. The definition of companion animal includes birds. And so what we were suggesting was replacing the word foul with the definition that appears in Title 3.1.
Okay, I see three people lined up over here. I'm going to let Senator Stewart finish his inquiry and then jump to Obenshain. Go ahead. Stewart.
Mr. Chairman,
McDougal.
The foul is concerning us. There's some specific statutes about recovery for damage of fowl if they're killed in some way. Frequently, we see this occur with companion animals killing fowl, and then there's some sort of litigation that's involved with the euthanization of the companion animals when they kill the dog. So my question is, if you let your dogs out and you know that they like ducks and they go into somebody's chicken coop and kill 2 or 3 chickens or ducks, did you maliciously let the dog out so they could kill the fowl? I think the fowl is what we're all having questions with. And so I'd probably, at the appropriate time, make a motion to remove fowl from this.
Mr. Chairman.
Okay, Senator Obenshain.
Those ducks in a coop, those chickens or turkeys in a house, that's livestock. Isn't that already covered if you take fowl out?
On line 13, it says or other livestock.
Mr. Chair.
We have a definition of livestock somewhere, right?
There's another hand up. Senator Deeds, and then
I don't think fowl's included in the definition of livestock that's in the code.
Okay.
Mr. Chairman, I do have the definition of livestock here.
Where is that, Steve?
Okay, it is It's on my iPad. I don't have the code section. It would be, Taylor?
Mr. Chair, I do see one in 3.2, 5400.
Okay, but that definition only applies to that title. It wouldn't apply to 18.2, right?
That's correct.
Unless we incorporate it.
That's right, unless we reference it, but
Well, here's the problem. The definition of livestock lists a number of things that aren't birds, but then concludes with, or any other individual animal specifically raised for food or fiber.
That does include fowl. I think you want to.
Okay. Was there, McDougall, do you still have your motion?
Yes.
Okay.
You're removing
Okay. Senator McDougall? Sorry, Senator McDougall, your motion would be to remove foul from line 13 and 14
And 15?
and restore it to 17. Is that right, or am I imagining things?
Yes. Well, I'm not trying to change the law. I'm trying to, for foul, just return it back. So I think it looks like come out on 14, 15, and be reinstated on 17.
Right.
Okay, it's been moved and seconded. Is there any further discussion? Senator Eben, where are you on foul?
I'm after dogs and cats, so I'm okay. Or
Okay.
parakeet. I guess a parakeet that's a companion animal would be still covered, right?
Yeah.
Yeah, that'd be fine.
Peacocks.
It's, yeah.
Peacocks.
I would think a parakeet or whatever would fall under any companion animal of another. Yeah. Okay. Any other discussion about that amendment? All those in favor say aye. Aye. Anybody opposed? Okay. We've made that amendment. Is there any further questions for Senator Eben? Okay. Before you have anybody speak in favor, is there anybody who's opposed to this bill? Anybody out there has any concerns about the bill before some people testify and take victory from the jaws of defeat? No. Okay. Senator Eben, do you still want your people to testify?
I don't know if that's necessary, but they're.
Doesn't look like
yeah,
it.
I think we're doing good.
Okay.
Move to report.
All right, it's been.
Second.
Okay. Michael reminds me this needs to be reviewed in the Finance Committee. You want to modify your motion?
Move to report and re-refer to finance, Mr. Chairman.
Okay, it's been moved and seconded that we report and re-refer the bill to Finance. Indicate your vote on the voting board.
Ayes,
Mr. Chairman, you.
ayes 14,
I didn't do it.
ayes 15, no zero. Your vote will be noted, sir.
Show me as a yes. My screen isn't working here very well. Okay, Senator Eben, what do you got next for us?
SB 362, which is dealing with first-time drug offenders, and I do have a line amendment that council has, or I can read it. I think they can pass it out. Do you want me to explain the bill while they're passing it out, or I shall wait until you adopt it? Okay. This is for first-time drug offender reform. It provides that a person who's not been previously convicted of a felony offense be eligible for first-time drug offender disposition. Under current law, such disposition is limited to any person who's not been convicted of any criminal drug offense. And the line amendment just makes it clear on line 41 that marijuana is not currently, having a previous marijuana conviction is not a bar to joining the first offender program for people charged with the drug possession. And the second issue in the bill is that the first offender requirements are a bit onerous in terms of the hours of community service. We had it at 24 hours for a number of years, and then I believe when we passed the bill to allow marijuana offenders to get a driver's license, we raised it up to 100 hours of community service, and this takes it back to the 24 we were at before. The bill strikes language saying that a person must remain drug and alcohol free during the probationary period because the law should recognize that people in recovery sometimes test positive but could be on the right track, and the bill still requires drug testing because that allows their treatment needs to be accurately assessed and addressed. It removes the alcohol-free requirement because that's not really relevant to a illegal drug crime. And finally, the bill gives some discretion to judges to determine the final outcome of the case if the person has violated the terms of their probation. Currently, many judges interpret the law to mean that the court should enter a felony conviction and sentence the person. This bill gives the judge the flexibility to enter a disposition they find appropriate under the circumstances. That could be a felony conviction, a misdemeanor conviction, or continued deferral with conditions. And I do have some witnesses who are very familiar with this issue and how the program is working currently.
All right, Senator, let me see if I can summarize it. A few people here aren't lawyers, may not understand it, but so right now, if you get any kind of drug offense, first time in your life, one of the deals you can do is you can stipulate you're guilty, and then it's continued for a period of time and dismissed. And I would say that probably 90% of them that exist have been done for marijuana possessions in the past, the ones that are out there. But once you do it, you can't get it on other drugs. If you get a cocaine possession after you have a marijuana case, continued for dismissal. You can't do another continued for dismissal on the cocaine charge. And what this would do, it would say that if you get a felony drug possession and you had a prior marijuana charge that was continued for dismissal, you can do it. You can do the continued for dismissal on the felony if we make this change.
That's correct.
Plus, you're reducing the community service from 100 hours to 24. I think that's mainly what this bill does, right?
Yes, those are the two main things.
Okay, Senator McDougall has questions.
Chairman, to understand, if you had a charge for possession of heroin that was taken under advisement, you complied with everything the court asked you to do, and that was dismissed, you don't have a conviction. You get a second charge 5 years later. 1 year later. Or 1 year later. Now, are you required to have this taken under advisement because you've never had a conviction?
The way I read it, Senator McDougall, is if your first 251 disposition was for a misdemeanor, you can do a second one on a felony. If your first one was for a felony, you can still only do it once in your life.
Okay.
Mr. Chairman.
And I think Senator Evans, or Michael or somebody, we didn't do the amendment, did we? We haven't done that yet.
Yeah, we did not adopt the line amendment now. That was
Okay.
passed.
Well, let's do the amendment first, get this in the right posture. Is there a motion to adopt his line amendment?
So moved.
Is there a second? Okay, it's been moved and seconded. We adopt the line amendment. All those in favor say aye. Aye. Anybody opposed? Okay, Senator Stewart.
Thank you, Mr. Chairman. To somebody, is there any other misdemeanor conviction other than marijuana?
For 251?
Any other drugs that were misdemeanors?
For 251?
Mr. Chairman.
Okay, Senator.
Senator
Perry has an answer.
Nobody.
Possession of Schedule 3 would be a Class 1 misdemeanor. There's also PWID marijuana misdemeanor, several different misdemeanor offenses. Possession of Schedule 4, 5, 6, those are all different level of misdemeanor possession charges.
Okay, thank you.
It's good to have another former prosecutor on here. Okay. Any other questions? Okay. Senator Eben.
Yes.
Do you have anybody?
I do have two witnesses who'd like to just say a brief word.
Okay.
Good morning, Mr. Chairman, committee members. My name is Mike Launcher. I'm the Chief Public Defender in the town and county of Bedford, small rural jurisdiction between Roanoke and Lynchburg. I've been one of the ones that's been talking about this bill for a couple of years, since marijuana was decriminalized in 2020. And part of that reason is there was an unpublished Court of Appeals case that came out in July of 2021 that ran through our office. We had a client who in 2007 had a marijuana charge taken under advisement and dismissed. 13 years later, he was charged with possession of methamphetamine. We entered his plea in late August of 2020 after the decriminalization had gone through. At that point, we asked the circuit court judge to take the matter under advisement as the marijuana charge was no longer a criminal offense conviction, or that prior proceeding was no longer such an offense, meaning a criminal offense. There were some things that we argued there that when the legislature decriminalized marijuana, they intended for it not to be criminal, and that those ramifications should be more than just new charges. We also argued that this was something that the Virginia Sentencing Commission supported. They had issued a letter, I believe in June of that year, 2020, saying that they were no longer going to use prior marijuana convictions, to calculate the sentencing guidelines. And so we felt that if prior convictions weren't going to be used as a criminal offense in the sentencing guidelines, that we had a good faith argument to make that those offenses were no longer criminal for purposes of the first offender statute. Unfortunately, our circuit court judge decided against us, and that matter was upheld on appeal. The Court of Appeals basically said that at the time of the deferral, when the marijuana offense happened in 2007, it was criminal, and in looking at the statute, that was a use of the first offender. The court did talk about legislative intent at that point, saying that the legislative clearly could have amended it, the first offender statute, to make that change, and it did not do so. So that's part of what we're asking, is that the legislature do that now. This kind of dovetails with what the police captain talked about earlier, the sealing and expungement. That's going to happen for all the marijuana charges. And so it seems appropriate, especially now that we've gone from decriminalization to full legalization, that this change be made.
Mr. Chair, could I ask a question?
Senator Deeds.
Yes, sir.
I'm interested primarily in the second part of the bill. Have you found people that have gotten the first offender status have not been able to complete it because of the community service?
We see that quite a bit, Senator. When we have the review at the end of the 12-month period, many times it's the community service requirement.
Many times quantify that for me, please. What percentage of your cases? I'm sorry, Mr.
I'd say in at least half of my 251 cases that at the final review date, my client has not yet completed the 100 hours of community service.
And Mr. Chair,
Senator Deeds.
Are they given additional time by the court typically or not?
Generally, we are able to continue it to get some extra time for them to do it. And I'd say of those people, 2/3 completed.
Okay.
Okay.
Thank you.
Great. Thanks.
Mr. Chair.
Senator Perry.
And at the time when they reach that year end of the people who haven't completed their community services 100 hours, can you give an estimate on roughly how many hours they have completed, or are these people who haven't completed any? Where are we at on that?
Let's see.
I'd say it's usually between not having done any at all and maybe 25 to 30 hours.
Substantial compliance, or not, maybe less than half?
Correct.
Okay, thank you.
Okay, and by the way, to the committee members, I see some people are using the screen to say they want to speak, and I keep losing track of it. So, Senator Stanley. I know I missed Senator Jordan earlier. I apologize for that.
If you want to go first?
No, different bill. Senator Stanley.
Hey, Mike, welcome to the Capitol, brother.
Thanks,
you and
Senator.
I are in the halls all the time on this stuff, and when we get first offender status, one of the big things you're trying to do is make sure that they remain drug free. I get the alcohol; it's a legal product. I get now marijuana, but that's not just an aspirational thing. It is a part of this. And many times, you and I have been before the same judges where if they got one dirty screen, two dirty screens, they all take that into account. Why is it necessary to remove, as this bill purports to do, the admonition as a condition of the probation that you remain drug, and it says drug and alcohol free during the period of probation?
Because I think there are a lot of judges that see that and say, if there's one positive test, they're going to revoke and convict somebody.
Have you found that?
Not in my jurisdiction, but I believe in other jurisdictions there are circuit court judges that would do exactly that.
I've been in a lot of Mr. Chairman.
Senator Stanley.
I've been in a lot of jurisdictions, and I haven't found one that's done the one and you're done yet, and they may exist. But if we remove that as a condition of probation, doesn't that encourage the bad behavior we're trying to stop, or at least not even acknowledge the importance of trying to stop using drugs?
I think by removing it as that condition, you take it away from that very small percentage of judges that may go one and done. I think the statute, as the pro's written, still continues to say submit to tests during the period of probation, and that can be a violation. I think what this amendment does, Senator, is it sets up the first offender to essentially be a drug court program for those jurisdictions that don't have it, that don't have the resources to be in a drug court. In a drug court, you're not going to be one and done. And so by testing and coming back, if there's some positive tests, with this statute, the probation officer could write the letter, get somebody back in court, and the judge could say, I don't have to convict you of this at this point. I can use the other means at my disposition and essentially treat this first disposition as a drug court in the jurisdictions that don't have the resources to have one.
Thank you, Mr. Chairman.
Mr. Chairman.
Senator, is that Perry? Yeah.
Yes. If I could follow up, I'll be honest with you, my biggest concern is that removal of the drug and alcohol testing requirement from the statute. I spent a lot of time on the Loudoun County Drug Court and helped reestablish that program. And I know Senator Eben mentioned briefly the alcohol is separate from the reason that they're there, and while that is accurate sometimes, but I will say that alcohol is still considered a drug and is recognized as a drug. And what we found is that oftentimes what happens is when someone gets clean off of one particular drug or tries to remove themselves from one particular drug, they opt out for another drug, often alcohol. And so we end up seeing situations where they have just substituted for another substance. What I have, and so that is why I believe the motivation behind why it was drug and alcohol free to begin with, even though it is geared towards substances, not drug substances, not alcohol substances. My question is really, though, related to remaining drug and alcohol free and the coming back. Certainly, the law was amended to allow for a first-time probation violation. So if someone were to come back after a test for testing positive, testing dirty, as it's colloquially referred to, they wouldn't be subject to jail time, for instance, and the court certainly has a wide deal of latitude on what to do, but many, if not most, if not all of these people are also in substance abuse programs where we are trying to focus on everyone in that program being clean, and it can be detrimental to the success of other folks in the program. If I, for instance, were allowed to be on a 251 disposition, as this is called, and use cocaine every single day to the other folks in my program. And I guess my question is, have you guys looked at, or what is your response as to the other people in these substance abuse programs and the continual use of substances and narcotics? To me, it's a separate issue what the court ends up doing with a positive test. Certainly, I'm in favor of treatment, but I think not to order it at all is problematic for those rehabilitation programs.
The bill doesn't remove the requirement for drug testing, but alcohol is correct. There's still drug testing under this legislation.
Yeah, I understand there's testing, but there's no order. This strikes the language about the use, that you can continue to use drugs and alcohol while on probation freely and liberally. They can test you, certainly, but there's no requirement from the court that you don't use. And my question is related to the impact on rehabilitation programs that people are in and the other folks in those programs. I'll tell you all that my superintendent asked specifically that I carry a bill, and I have filed a budget amendment related to substance abuse schools for kids who are overdosing on fentanyl and other drug uses because the issue has gotten so bad in the schools. And the reason is those kids are going back into an environment where other people are using it. It's becoming detrimental to them being able to rehabilitate themselves and get themselves off of drugs. So I'm concerned about this being permitted and permissive and given authority to continue to use whenever these people, again, are in rehabilitation programs with other people and the impact on all of those folks who are trying to get clean.
Mr. Chairman.
Hold on. Good questions, Senator Perry. Just want to remind everybody to go through the chair when you have a follow-up question. Not Senator, it's Chap Peterson's talk.
I'm just a lawyer.
My apologies,
Mr. Benjamin.
I'm just a lawyer. Thank you, Mr. Chairman. Mr. Chairman and Senator Perry, I think that the bill does not permit drug use. The primary requirement you find at line 25, as a term of condition of deferred disposition, the court is required to require a substance abuse assessment and then enter such treatment as may be necessary. And then continuing further down to line 38, you see again the requirement that the accused successfully complete a treatment or a drug education program. And so the judge always has the discretion to determine whether somebody is truly making progress in the drug treatment program or not, and has the discretion to, if the positive tests show that they are not making progress, to kick them out of the program. So I don't think that this bill has the effect of permitting drug use. It just recognizes what the rehabilitation community has taught us, that relapse is part of obtaining sobriety.
Okay, any other questions? Senator Carol Foy.
Yeah, thank you, Mr. Chairman. So first, I want to thank the patron of the bill for bringing this bill. I can say that the studies have now shown that relapse is a part of recovery, and studies show that an average person relapses at least 7 times before they're actually on the road to recovery. I think that this bill also acknowledges the fact that substance addiction is a mental health issue, and as a society, we are now treating substance addiction as a mental health issue, and we now realize that we can't incarcerate ourselves out of addiction. So I appreciate this bill because it reflects a number of those principles, also relating to the community service. I appreciate the fact that these bodies realized several years ago, even though many people in the criminal defense community said that, for example, suspending licenses was overly punitive, unnecessary, and it actually precluded people from being productive, returning members of society. And I believe the community service piece in this does that as well. I can tell you that representing indigent clients who are charged with substance addiction, usually possession, that at the end of the day, when we put more barriers in place to keep them from being successful, what that does is make them recidivists. So we tell them to get a job, we tell them to get housing, we tell them to get their children, we tell them to get off drugs, and also do 100 hours of community service. So we talk about creating more challenges and barriers when we say we also want people to come back into society and do well. We need to make the road to recovery easier, not more difficult. And to say 100 hours of community service when someone's already in the throes of an addiction, having to go to treatment and courses and classes and do all of the things and pay for court costs and pay for restitution and put all of these stipulations on the people, I can tell you that we are setting our folks up for failure. And if we want people to address their addiction, let's do everything we can to make that possible and not put needless, unnecessary barriers in place. So I do not support the 100 hours of community service. I do not think that benefits the individual nor society and help can create more recidivism. And that I do appreciate this bill on so many levels as a indigent defense attorney. Thank you.
And the question is, isn't that right? Senator Jordan, thank you for being patient with my ignoring your name in the queue here.
Thank you, Mr. Chair. Senator Eben, I appreciate your bill, actually. My only concern is that the loss of life that may occur. We do know that judges have discretion, and removing this provision of probation might take away the carrot I see from preventing relapse. But judges do have discretion.
Say that again.
It would take away the carrot that judges have to ensure compliance of preventing relapse. What would you say, besides community service, would be, and judges do have discretion in this crossroads if someone relapses. What would you say the carrot is if this provision is removed?
The carrot is that you could get your disposition deferred if you successfully complete the program, and that you can see the ability to get to 24 hours of service rather than going to meetings every single day and trying to also do 100 hours in addition to if you're working full-time or something, that you can see the light at the end of the tunnel and that it's more obtainable, and that if you have one positive test, that you can talk to the judge and tell them it's not going to occur again, and the judge can measure whether that occurs again. So I think the carrot is the deferred disposition being obtainable and not fearing that if you fall off the wagon once that you're done and that you just go back into using drugs.
Follow-up question, Mr. Chair.
Senator Jordan.
Thank you, Mr. Chair. Senator Eben, what would you say, though? I've sat through drug courts in the back, and I've sat through and I have seen judges give discretion to those with kindness to understand that relapse occurs. If this provision is removed, would you be comfortable with the loss of life that could occur without having the drug testing in place?
This does not remove drug testing. I think Mr. Benjamin clarified that that the court would. What line is that on? It says that you still have to successfully submit to tests on line 40 during the period of probation.
Senator, I'm sorry, I mischaracterized that. It removes the ability for them to enforce anything once that drug test is submitted to the court. So essentially, once they complete community service.
No, they don't have to find, I don't think they have to give someone a deferred disposition unless they've satisfied the court's requirements for treatment. And I can't imagine a treatment program that you'd successfully complete where you were repeatedly testing positive for substances.
Right. Right. Okay. Sorry. There's a question over here. Senator Stewart.
Thank you, Mr. Chairman. So, Senator Ubben, I actually like the premise of this bill, and I want to see how you feel about the parts that we've been discussing. So, in defending and prosecuting people for probably 30 years, one of the things that I have seen is they need that impetus of remaining drug and alcohol free. And the community service seems like a big burden, but I actually have seen that community service be a big benefit to people because it makes them get out, it makes them do things. And I understand they have to find employment too. But the whole idea had given them a first offender program, and I like this. I like the idea of the first offender program that you've proposed today. But I have concerns about striking those two things. Would you consider it a friendly amendment if we unstruck the language?
Please go make it. Let him make it.
You want me to be quiet then?
Yes.
All right.
You can do it for us if you want.
All right, I'm going to make a motion then that we unstrike the language on 39, line 39, and
Is it drug or drug and alcohol that you want there?
and 42.
And 43. You'd have to get 43 too.
Yeah.
You'd have to basically unstrike everything between 38 and 40.
Unstrike everything from 39 to 43. Thank you.
Yeah.
I should have let Cree do it.
Okay, is there a second for that? Second. Okay, is there any further discussion about that specific motion?
Mr. Chairman?
Yeah.
Just want to comment
no,
on...
Hold on, council has a question.
Mr. Chair, I just want to check because one of the initial amendments that was adopted did separate out drugs other than a drug prescribed by a doctor or marijuana. Do we still want to keep that carve out or just restore the current language under current law as is?
Sorry, 41 inserted, let's see, strike drug other than a drug. So you're, Taylor, you're saying that we still want to make it possible to test positive for marijuana that's prescribed by a doctor?
That's
I think
correct.
the answer to that is yes, because it's been prescribed by a doctor, is I think, right? Senator Stewart, is your motion?
We have to leave that in because marijuana is legal or a doctor's prescription would be legal.
Yeah.
And Mr. Chair, I do want to clarify that the amendment currently reads
Mr.
any
Chairman.
drug prescribed by a doctor or marijuana, so not limited to medical marijuana. So if you
Good lawyerly clarification. I hear a noise down to my right. Senator Perry?
Mr. Chairman, I would say that we leave it as things that are prescribed. I would exclude marijuana unless it is prescribed by a doctor, just like any other drug. Amen. Similar to removing alcohol because it's also a substance, although not required to be prescribed.
Okay.
Although many people.
Why don't we take this in two parts?
That's my amended
Okay,
motion.
hold
Mr.
on. Why
Chairman.
don't we take this in, we've already adopted this one. I think there's a two-step dance we got to do here. So in terms of Senator Stewart's first motion, is there any further discussion about that motion? Okay, all those in favor say aye. Aye. Anybody opposed? Yep, okay. Now, having voted in the prevailing, is there a motion to reconsider the adoption of Senator Evans' initial line amendment so we can go back and fix that? Is there a second? All those in favor of reconsidering say aye. Is that recorded, Michael? No? Okay. Say aye. Anybody opposed? No. Okay, so now the line amendment is back before us. Senator Evans, what do you want to say?
I just wanted to make one suggestion. On line 42, where it says at least 100 hours of community service for a felony and up to 24 for a misdemeanor, perhaps we could change it to at least 24 hours for a felony if you want to have a more than 24 option. No? You prefer it like it is?
I think you're tempting fate.
I think you got really good, broad bipartisan support on this bill, Senator.
Thank
Okay,
you.
so Senator Evans' original line amendment, we need to have a motion to readopt that minus or marijuana.
So moved.
Been moved and seconded, we adopt that revised floor amendment. All those in favor say, sorry, line amendment, say aye.
Aye.
Aye. Anybody opposed? Okay. So now we have this revised bill in front of us that's taken a lot longer than I expected. And I think it's in pretty good shape. Does anybody else want to try to steal victory from the jaws of, defeat from the jaws of victory?
Mr. Chair.
Mr. Chair, just one question.
Senator Peak does.
Senator Peak, okay.
Mr. Chair.
Oh, there you
Taylor, I apologize if this was already said. I just, for my own clarification, want to confirm whether or not we're keeping alcohol or not.
Huh? Where?
Yes.
In the drug testing.
Yeah.
Keep the alcohol language stricken or in the.
No, alcohol's back.
Remain.
Drug and alcohol free is back in.
Okay, thank you.
Okay.
Mr. Chair.
Senator Peak.
Now, I just want to clarify what I think the community service hours are. Still, it is still going to be 100 for a felony and then 24 for a misdemeanor.
Yes, sir.
Thank you.
Okay. Is there anybody opposed to this bill?
They must have.
Nobody.
Move to report as amended.
Second.
Okay, we got our first bill going to the floor of this committee. All those in favor, please record your vote on the board.
Ayes 15, no zero.
All right, good work, Senator Eben. Didn't see that coming at the beginning
Thank
of
you,
this.
members of the committee. Thank you, Mr. Chairman.
Okay, ladies and gentlemen, I have a couple witnesses, doctors who have patients at 9 o'clock who I didn't think that was going to take so long. So I'm going to go do my bill really quick. Senator Deed's going to take over, and then we're going to come back to Senator Head, D. Steph Diggs, and Van Valkenburg in that order. Reeves is last on the list. Oh, and by the way, I also need a motion to take Senate Bills 7 and 120, the hate crime bills, by for the day. Is there a motion to do that? Is there a second? All those in favor say aye. Aye. All those opposed, no. So the hate crime bills, the ethnicity thing, that's gone for today. Senator Deeds.
Okay, what's the bill, number of your bill, Senator?
Optometrists, it's
254. 254.
254. Okay. Senate Bill 254, give Senator Servell your attention.
This bill is a pretty simple situation. About 15 years ago, the Supreme Court of Virginia decided a case called John versus M, where the Supreme Court said in a civil case, actually in criminal cases too, that an expert witness is not allowed to testify as to a medical expert is not allowed to testify to causation of damages. So they can't testify that something caused the condition unless the person is a licensed medical doctor, because of the way our statutes are written, because the way our licensing statutes are written, diagnosis is not entirely within the scope of certain professions. So in 2014, we added language to say that physician's assistants are allowed to testify to causation. In 2015, we added nurse practitioners. We also added podiatrists. This adds optometrists.
Yeah, I think we get it. Are there people that are opposed to this bill?
I don't think so.
Are there questions from the committee? Are there people that want to testify, that want to grasp victory from the jaws of defeat? Or grab defeat from the jaws of victory? Yeah. Okay, is there a motion on the bill?
Move to report.
Okay.
Okay, any other discussion? Open the roll. Okay, thank you, Senator. You were very convincing. Bill reports.
Ayes 15, no zero.
Okay, so Senator Head is up next. With a very specific, super specific, situational type bill.
Indeed. Thank you, Mr. Chairman and members of the committee. This bill was brought to me by the Public Safety Office from Roanoke College, and they are faced with a rather unique situation. This group is it's an SCOP department, and they are already they have a memorandum of understanding with the Salem Police and every member of the force is a retired law enforcement officer. And in the event that there is ever a crisis situation, and this is really what their concern was, if there was an active shooter situation or some other crisis situation on campus, or because of that memorandum of understanding, if they were actually called in to assist with any sort of a crisis situation in the city of Salem, which they could be under that MOU, the utilization of being able to deploy rifles in the event that were necessary, they're a little concerned because right now the code appears to restrict them from being able to do that, or it doesn't give them the explicit capability of doing that. But it would if they were reclassified as armed security. And that was the initial thing that was put forward, is just declare yourselves as armed security instead of SCOPs. And if they did that, that would put them in a different posture so that they would not be able to investigate any criminal activity that occurred on campus, only to intervene in something that they actually observed, which is what they'd have to do if they were armed security. So they were in something of a quandary with this, and they asked if we could put something together and came up with a language that would very narrowly tailor the opportunity to only those SCOPs that are in an MOU with local law enforcement, only in those SCOPs that are also properly trained as police officers, and only those SCOPs that are providing police operations in an institution of higher learning. So it's very, very narrowly tailored to try to address their specific situation.
Senator Hatt, this is for Roanoke College?
Yes, it's Roanoke College.
Got it. Does anybody have any questions for Senator Head about this bill that he thinks probably only applies to Roanoke College? No? Huh? Oh, it does? Okay. All right. No questions. Anybody in support? Anybody opposed?
Move to report.
This bill has to go to finance. Is there a motion to refer to finance? If there's a second, any further discussion, please open the vote.
Ayes 15, no zero.
Great. Congratulations, Senator, Head of your first bill out as a senator, I think, probably, right? Good work. Okay, next up, we have Senator DeSteph. Is he back there still?
Yep.
I can't see. Oh, he took off. Okay. Oh, he's back. DeSteph, you're up. What do you want to do first, 193 or 265? Fleeing an officer, 193, fleeing from a law enforcement officer, trying to reverse the Court of Appeals of Virginia.
Mr. Chair, members of the committee. So what we're trying to do here with Senate Bill 193 is strike the and immediate physical activity, ability in line 3233 of the bill. And what happened was last year, Lynchburg Circuit Court determined that beyond 20 yards did not meet that requirement. The issue we have with this is if you're on a police boat and you're trying to get somebody going 65 or 70 and you are getting within 20 yards, you're going to run into a serious issue. In this court case, which I believe was from Judge Frederick, Catherine French was the appellate judge, but Judge Raphael was one who said, although the defendant here knowingly fled from law enforcement officer attempting to arrest him, the officer got no closer than 20 yards. Well, in a high-speed chase, it's hard to get sometimes within 20 yards and some other things. So pretty much in areas like this, a defendant does know that they are under arrest or a police officer is attempting to pull them over, stop them for something they're doing wrong. Virginia, and in that case, we found out that Virginia was the only, as they put it, the only state in the country that requires this close proximity to an officer as an element of the crime. So existing code requires that the officer have the legal authority, which they have. The officer communicate to the offender that they're under arrest, which they have. And a reasonable person who receives such communication knows or should know that he or she is not free to leave. So I believe all the elements are met there. So that's pretty much the bill. Happy to answer any questions.
Okay. So Senator DeSteph, basically the Court of Appeals ruled that in order for you to be able to be charged with fleeing, legally responsible not to flee, you have to be the officer has to be capable of immediately apprehending you. So in other words, you have to be pretty close to the officer before fleeing becomes a crime.
Mr.
And you
Chairman,
would like to
within
change
20
this so that if
yards.
somebody's like 100 yards away and the police officer says, hey, stop, and they run, they could now be charged with a crime. That's what your bill would do, right?
Well, Mr. Chairman, pretty much, but it says that the close proximity, because of different circumstances, would not be just 20 yards. And again, a boat, a high-speed chase, even a jet ski, trying to pull them over, you are not going to get within 20 yards if you're doing 60 or 70 miles an hour.
Okay. Are there any questions for Senator DeSteph? Senator Carol Foy.
Thank you, Mr. Chairman. So it appears as if you want this to apply to the, I guess, very specific circumstance of chase on water. So if there's a boat chase or, as you say, on jet skis, then can you put that in the language that it applies to, or can it be changed or amended to effectuate that? Because I believe what the statute is trying to do is make sure that the officer can effectuate the arrest. So if, there's an officer that's almost a football length away from a person and screams, you're under arrest, and the person just takes off. Maybe they didn't hear it. Maybe it was loud. There could be a number of circumstances. I believe the purpose or the underlying premise of the immediate span of control is because you want the officer to be able to effectuate the arrest or be in a position where they can actually take the person into custody at that time. Would you consider that an amendment that's acceptable?
Mr. Chair, Senator Foy, actually, if you read the existing code, the code says it requires that the officer have the legal authority, the officer communicate to the offender that they're under arrest, and the reasonable person who receives such communications knows or should know that he or she is not free to leave. So, Mr. Chairman, Senator Foy, they would already have to hear it. The officer has legal authority and has communicated that the offender is under the arrest, and a reasonable person receives such communications. That's still part of the law. That's still in the law. What I'm trying to do is pretty much line Virginia up with the rest of the country and say that there are certain circumstances that the immediate physical ability does not apply.
Mr. Chairman.
Senator Stewart.
Senator Steph, I'm just curious, based upon what you're proposing here, if an officer was in the city of Richmond and he texted or Skyped or whatever somebody who was in Ashland an order to stop, and it was a lawful order and he received it, and he didn't, would he be guilty under your bill?
Mr. Chairman, Senator Stewart, I would have to defer to Mr. Benjamin to help me with the assistance of that, because I'm not completely familiar with the criminal code, where I know he is one of the subject matter experts that could answer that question. But I don't believe you can text somebody.
The officer communicates to the person that he is under arrest. The officer has the legal authority to place the person under arrest, and a reasonable person receives such communication. So you're in the same jurisdiction,
right,
Virginia, and you tell them to do it by text or other electronic means, and if they choose not to stay there, they are guilty under this statute.
Right. So, Mr. Benjamin, so I've heard some talk about jet skis. We also have a speeding to elude statute, which is 462817, which only applies to motor vehicles versus boats. If he was concerned about a vehicle and boat, wouldn't it more appropriately go there instead of in this statute, which has more to do with fleeing on foot and person-to-person encounters?
We have, Mr. Chairman, existing statute that covers eluding by boat or other vessel.
Oh, we do? Okay.
We do already.
Okay. So then this is mainly focused on human beings, like communicating with each other, not in vehicles or boats.
Mr. Chairman,
Okay.
just to give you and the committee some historical context, this question goes back to at least the 2002 session. And I know that Senator Steph has been working on this very issue for many, many sessions. But beginning in 2002, when various patrons wanted to criminalize fleeing from a law enforcement officer with no force, nothing else, various compromises were struck, because the concern historically on this committee has been that there are some folks who reasonably choose to flee from law enforcement. And the compromise has always included an officer having the immediate ability to place somebody under arrest so that you don't have a 100-yard or more situation.
Okay. So this would undo our careful compromise from
Of
10,
some 20
ago.
years or so.
20
yes.
years ago. Got it. Got it, Senator Dista.
Understood, Mr. Chairman. Mr. Benjamin, the issue I have is that we've now said that you have to get closer than 20 yards based on this circuit court case in Lynchburg. And 20 yards is not that far.
Got it. All right. Are there any other questions for Senator Dista? Anybody in favor of the bill?
Mr. Chair.
Okay. Well, let's see if there's anybody. Oh, one in favor. Okay, and then Senator Perry, you have a. We'll get to your question. Let's do the in favor and opposed, and then questions.
Good morning, Elizabeth Hobbs with the Virginia Sheriff's Association. We are in favor of this bill. Thank you.
Okay. Thank you, Elizabeth. One more.
Good morning, Mr. Chairman. Dylan Bishop on behalf of the Virginia Law Enforcement Sheriffs, and we too support the legislation.
The Virginia which?
Virginia Law Enforcement Sheriffs, so the sheriffs that have the primary police responsibility in their locality. Thank you,
Got
sir.
it. Thank you. Okay, is there anybody opposed to the bill? That's surprising. Okay, Senator Perry, you had a question?
I just wanted to say to Senator DeStaff, I understand the issue, and I know there's a lot of law enforcement officers who have a difficult time with this bill because of exactly the issue you're raising. And of course, we could throw up a million different hypotheticals about what if it's 100 yards or 500 yards or a football field or those kinds of things. But I think you are probably about 20 yards from me right now.
That's correct.
And
Senator
so,
Perry,
Mr. Chairman,
go ahead.
if I could continue.
Yeah, go ahead.
And so I think that there is a potential to try to get some language that maybe is more helpful to law enforcement than the particular language, but I think maybe we can sit down with counsel and other folks to see if we can work something out to try to address both issues.
Mr. Chairman, I'm happy to take this by for the day and see if we can come up with a resolution on that. Because, Mr. Chairman, as I said, 20 yards is pretty close.
Okay, I think it's a hard pull, but if you want to go by for the day and try and work on it, that's fine. There's motion to take about by for the day. All those in favor say aye. Aye. Anybody opposed? Great. Okay, Senator DeStaff, I think that's. Oh, you have one more. I'm sorry.
Mr. Chairman,
265.
Senate Bill 265.
And I thought we've seen this in prior years. From
Mr. Chairman, we've seen this last year as well, and I believe maybe the year before.
Right, which is why we put it on today's docket. So, okay.
Yes, sir, Mr. Chairman. And basically, this fine bill here protects information from a law enforcement officer having to provide to a court to disclose his residence, home telephone number, personal information concerning his family for any full-time or part-time law enforcement officer when he's testifying as a witness, unless that information is directly related to evidence in the case.
Okay.
So, Mr. Chairman, what we're trying to do here is protect our law enforcement's families and their personal residence, personal information from disclosure, from somebody just trying to find out where they live, provide information on their family. It's an opportunity to, unless it's directly related to the case. And I believe we have speakers on this as well, Mr. Chairman.
Okay. Counsel, is there anything else anywhere else in the code that says what people are not allowed to ask about at trial? Like where there's something in the code that says you're not allowed to ask a question of somebody like
The rape, Mr. Chairman, the rape shield law comes immediately to mind, but generally, well, sometimes.
Counsel agreed this could, in some cases, run afoul of constitutional right to confrontation if you were telling people they can't ask certain questions of witnesses.
I'm trying to remember.
Oh, I'm sorry.
Our comments when we were reviewing the bill, Mr. Chairman, but I think that one of our thoughts was that that aspect of the bill may not be necessary because a question can only be asked at trial if it elicits relevant information. And it's hard to imagine that this type of personal information would ever be relevant to a case.
Got it. Senator Peake is in the queue.
Yeah, we have that in all kinds of cases, sexual assaults, juveniles, where you protective orders, where you don't give the address of who it is or where they've moved. We specifically protect that information because we don't want an angry spouse to know where they're living or moved or what shelter they're in. So we've got now an officer testifying in open court in a drug case against gang members, and you don't want to protect his family from him giving his home address, which is completely irrelevant. So it may be irrelevant, but a judge might think that it is. So I think we need to put it in the code to protect our law enforcement officers.
Isn't that true? Okay. Any other questions? Senator? Okay. You're in favor?
Yes, Your Honor. Mr. Chairman, Robert Tracy from the Office of Attorney General. We also support this bill for the reasons that Senator Peake articulated. There is a relevance inquiry, but it depends upon the Commonwealth and the judge to either make the motion that it's inadmissible or not relevant and the judge to support it. So this is a presumption in law to protect law enforcement and their family against the disclosure of information that might intimidate law enforcement for testifying criminal cases. We urge your support.
Good morning, Mr. Chairman. Nathan Green, Commonwealth's Attorney for the City of Williamsburg and James City County. I just rise to point out that while there is the relevancy issue, a lot of jurisdictions don't get involved in certain misdemeanors and don't get involved in traffic offenses. And so when the officer is asked this question, it is not for the judge to raise objections, and there is no Commonwealth to raise the relevancy issue.
Nathan, I got a quick question. I'm trying to figure out if there's actually a problem here we're trying to solve. I mean, are you aware of any judge requiring a police officer to disclose his personal home address on the stand for or without a protective order in the case?
I am aware of certain judges that will not raise sua sponte.
That's a different issue. You're not answering my question. You're answering your question. My question was, are you aware of a specific judge?
Am I aware of a specific judge?
I'm trying to figure if we got a solution in search of a problem here. I mean, I'm not.
Mr. Chairman, I am aware of judges that will not sua sponte raise objections. And so if there is a relevant, if we are using relevance as a protection for these officers, I am saying that there are judges that will not do that.
Okay. Okay, who else in favor?
Good morning, Mr. Chairman, members. Dana Schrodden, on behalf of the Virginia Police Chiefs, we do support this legislation.
Okay, great. Sheriff's support?
Good morning, Elizabeth Hobbs, Virginia Sheriff's Association. We support this bill. It gives some power, if you will, back in the hands of the law enforcement officer who is testifying to not have to wait for an objection to be registered on his or her behalf. Thank you.
Mr. Chairman, once again, Dylan Bishop on behalf of the Virginia Law Enforcement Sheriffs, and we support the legislation as well. Thank you.
Thanks. Okay, is there anybody opposed to the bill? Senator D-Staff, you got the last word.
Mr. Chairman, members of the committee, thank you very much for your time today. I hope you support this fine bill.
Substitute motion.
It's been moved and reported. We have a substitute motion, Senator Deeds.
Move to pass by indefinitely.
Okay, is there a second for that? Okay, it's been moved. Substitute motion to pass the bill by indefinitely. Everybody open or record your vote.
Ayes 8, no 7.
Right. All right. Thank you, Senator
Mr.
DeStefano.
Chairman, members of the committee, thank you very much for your time.
All right. Next up, we have Diggs. Senator Diggs. Thought you had. I think you had one we took by today, didn't we?
Yes, sir. I'd like for you to pass by, Mr. Chairman, pass by SB 207.
207. Oh, you got a couple others. Okay. Got it. Which one you want to do first?
SB 197.
Okay. So you want to give our Attorney General the authority to prosecute some more local crimes?
Yes, sir.
Okay.
Essentially, this bill expands the jurisdiction of the Attorney General for criminal sexual assault of children only and sexual trafficking, again, against children only. The Attorney General already has concurrent authority in a number of cases, specifically involving child pornography and sexually explicit material. And this bill is a natural progression of the existing law to allow the Attorney General to prosecute sexual assault. It also expands the ability of the Attorney General to prosecute cases of commercial sex trafficking. This bill would help children and their families across the state where Commonwealth attorneys either refuse to prosecute or when local Commonwealth attorneys need additional assistance in prosecuting these cases. And several jurisdictions routinely request or permit the Attorney General's office to aid in such prosecutions. And this expands the jurisdiction of the Office of the Attorney General for children only. This bill is narrowly tailored, and it's a natural progression from the current authority to expand it to commercial sex trafficking, and which is often a multi-jurisdictional criminal offense, and to protect the children in our state from criminal sexual assault.
Right. Senator Diggs, any questions for Senator Diggs? Okay, let me guess, the Attorney General's in support.
Yes, Mr. Chairman, we are. For the reasons that were articulated, this is a natural enhancement over existing authority of offenses relating to the exploitation of children, images, child pornography, and such, and want to emphasize the multi-jurisdictional component of a lot of these commercial sex trafficking cases. I know in the past the committee has raised concerns about a race to the courthouse. The Attorney General's position is when it comes to protecting children, there should be multiple avenues of accountability against sex offenders. We encourage support of the bill. Thank you.
Administration supports.
Mr. Chairman, members of the committee, Josh Humphreys, Deputy Secretary of Public Safety and Homeland Security, the administration supports the legislation.
Thanks. Is there anybody opposed to the bill?
Good morning again, Mr. Chairman. Nathan Green, Commonwealth's Attorney for the City of Williamsburg and James City County, here speaking on behalf of the Association of Commonwealth Attorneys. I can't tell you how excited I am to stand up on my senator's first bill and oppose, but that is exactly what I do have to do. The Commonwealth attorneys are opposed to this. There is a number of tools the Commonwealth attorneys are given to help combat child sexual abuse. We have been tasked with putting together multidisciplinary teams. The attorney generals have not. We are the ones that are accountable to our communities every 4 years when we stand for election. And for that reason, we would ask that the Commonwealth attorneys be responsible for these cases. We absolutely welcome and would encourage the support of the Attorney General's office. And if there was language that put this in after the Romanet 5 with the concurrence of the Commonwealth Attorney, our opposition would change to a support. But as it's written right now, we do oppose.
Great. Thanks. And Senator Diggs, just remember, he learned how to do his job first in Fairfax, so maybe that has something to do with it.
Mr. Chairman.
Senator Stewart.
I'm going to ask Senator Diggs, do you have any objection to amending this bill to say with the concurrence of the Commonwealth's attorneys?
I would defer to the staff from the Attorney General's office.
So yes.
Sometimes it just,
So you agree?
We would ask that the bill be considered in its current form without additional authority.
Wrong answer.
But if that's, we understand that there's some opposition to the bill. But if we could pass this over for the time being, so I at least can get some guidance on that issue, our preference would be to keep the bill as it is.
Mr. Chairman,
Senator Stewart.
I'm going to make that motion, and then I could chat with Senator Diggs about it later. This bill has a long way to travel, and I think that, having been a former Commonwealth's attorney myself, I'd like to have a say in that before the AG comes in and takes the case over.
Second.
Understood. I would point out, I think under existing law, there is that concurrence that would be required, but thank you, sir.
So we have a motion in front of us, but I have a question for counsel. So either Taylor or Steve, under existing law, the AG can be brought in on a case like this if the Commonwealth attorney asks, and it goes, what, the multi-district grand jury, is that right?
Mr. Chairman, that's correct. Yes.
So what would this do? Just get rid of the multi-district grand jury step if this amendment were to be adopted?
Mr. Chairman, I don't follow that question.
Mr. Chairman.
Well, I'm sorry. So maybe Senator Perry can clarify, because she's actually done these kinds of cases from that side. Yeah.
I think what the bill is seeking to do, though, is to permit prosecution of these types of cases. The multi-jurisdictional grand jury, of course, doesn't prosecute. They just do it. They're just for investigative purposes. And so certainly the AG's office can be brought in on multi-jurisdictional grand juries, but this is seeking to allow for prosecution of human trafficking and hands-on sexual abuse cases, I believe. Senator Diggs can, of course, clarify.
So, Mr. Benjamin, Senator Perry, my understanding is that right now, the only way the AG can join in a prosecution is to go through a multi-district grand jury with the request of the Commonwealth attorney. And that this would say they can go through the regular local grand jury, partner with the local prosecutor to do it. I'm trying to figure out if this amendment does anything.
Mr. Chairman, I don't think the bill has anything to do with the multi-jurisdictional grand jury.
This one doesn't, but existing law does.
Currently, if a Commonwealth attorney were prosecuting one of these matters, and currently it would be in the Commonwealth attorney's discretion whether and how to prosecute one of these matters, if they desired the assistance of the Attorney General's office under existing law, they can ask for that assistance.
Okay.
What the amended bill does is permit the Attorney General, see, bear in mind that the statute begins with a prohibition against the Attorney General prosecuting cases, with a number of exceptions that follow. And what this bill does in the amended fashion is permit the Attorney General to prosecute one of these cases, but only with the concurrence of the local Commonwealth attorney.
Which they can already do today, is what you're saying.
Well, no, they can't prosecute. They can assist. Yes.
Mr. Chairman.
Okay, Senator Stewart.
And I get your concern and the turf war and the multi-jurisdictional grand jury, but it's cumbersome. And this could be a much better process if you've got a multi-jurisdictional sex trafficking case with children. And that's why I support it, but I think that we do need to bring the Commonwealth's attorneys in on this and their concurrence. I think that's what the bill ultimately does, is it gives some authority to do these multi-jurisdictional cases in a better fashion than the local Commonwealth attorney and the multi-jurisdictional grand jury.
Okay, so we have the amendment before us. Any other discussion about the amendment? All those in favor of the amendment say aye. Aye. Anybody opposed to the amendment? Okay, so now the bill is amended before us. I don't remember if I already asked whether there was anybody opposed to this. Anybody opposed? Okay.
Move to report. Second.
You said this has to go to finance, you said? Look at my list. What number is this? 197? Yeah, it has to go to finance.
Move to report and re-refer to finance. Second.
Okay, it's been moved and seconded that we report the bill and re-refer it to finance. Clerk will open the roll.
Ayes 9, no 6.
Senator Deeds, you escaped. Excellent. You got your first one. What do you got next?
Senate Bill 201. And I have an amendment.
Yes, Mr. Chair, and I can report the amendment quickly. It's on line 38. It would be after develop, add comma, in consultation with representatives of local law enforcement agencies, including representatives from the Virginia Sheriff's Association and the Virginia Association of Chiefs of Police, so that state police would have to consult with those agencies when coming up with the policies for universal standards for the Cody alert created by the bill.
Okay. Is there a motion to adopt the line amendment? Is there a second? All those in favor say aye. Aye. Anybody opposed? Okay, the amendment's adopted. Senator Diggs, why don't you explain this is a new kind of Amber Alert kind of thing you're talking about here.
Thank you, Mr. Chairman, members. This bill is an attempt to create a program to help find lost and missing children that is something less of the requirements of the current Amber Alert. The current Amber Alert requires the belief that a child has actually been abducted. And when we use the Amber Alert, there's a significant amount of children that are found very quickly. 73% of the children are recovered within 3 hours when an Amber Alert is issued. So this is very similar to our Amber Alert, but essentially would remove the criteria for a child actually being abducted. So we're looking for when a child may be lost in a shopping center or just lost from home or is not returned, and gives local law enforcement the authority to bring forth certain media responses. And this is certainly it's not a mandatory program. It's a voluntary program for both law enforcement and the media. And it's really tailored after an incident in the city of Hampton where a young child, Cody Bigsby, had been gone missing for quite some time, and nobody seemed to know, but he really never met the definition of the Amber Alert. So this bill is asking for the state police to adopt some programs certainly similar to the Amber Alert with some lesser requirements so that we can do the best we can to find lost and missing children who do not meet that criteria. And we certainly would like for our local sheriff's association and the chiefs of police to be part of that process of developing such policy.
Senator Diggs, I think the concern that we had when we were talking about this before the hearing was we already have, I think, Amber Alerts, and we have these Silver Alerts now, I think.
Yes.
And there's a concern that we start having too many of these alerts, it's going to sort of dilute the effectiveness of these alerts if you're getting alerts all the time and your phone's going off and stuff. So can you talk about why you think this specific scenario deserves that level of attention as compared with Amber and Silver?
Yes, sir. The goal is certainly to help find lost children as quickly as we can, and it's not a mandatory program, nor does it require law enforcement to actually implement the program or to activate it. It's just an additional tool in the toolbox for those situations where we need additional media and other resources come to bear without it actually rising to the level of a Amber Alert.
Okay. Do you have people here to testify in favor?
I believe we had some people who were planning to be here. I think they may have got scared off by the potential weather enrichment.
I'm just trying to figure out whether we need to set a timer or not. So, okay. All those in favor, please step up to the podium.
Oh, sorry.
Mr. Chairman, Dylan Bishop, on behalf of the Virginia Law Enforcement Sheriffs, we support the intent of the bill, but I'm glad we have a chance early on in session to address this. Just a cautionary note on the language that was added. It specifically cites the Chiefs of Police Association and the Virginia Sheriff's Association. I would recommend moving forward, if we could, just general references to sheriffs or chiefs generally, or that these line item amendments also include the Virginia law enforcement sheriffs. We are the sheriffs that have the primary police authority in their district and localities and cover a huge swath of the Commonwealth. So just wanted to leave that parting note with you, Mr. Chair. Thank you.
You want us to mediate that internal fight?
That would be nice, sir. But no, if we could just make references generally to sheriffs or chiefs of police, I think that would be best for the Commonwealth as a whole. Thank you.
Got it. Now, the Sheriff's Association.
Good morning, Mr. Chairman and members of the committee. I'm John Jones, representing the Virginia Sheriff's Association, and we represent 119 of the 123 sheriffs. In the interest of all of the sheriffs, we support the bill and the amendment. Thank you.
Okay. Anybody else in favor? No. Is there anybody opposed to the bill? It's a lot of new words in the code you're putting in here. I'm surprised not more people here to talk about it. Any other questions for Senator Diggs? This bill does not have to go to finance, according to. Okay. All right. It's been moved and seconded that we report this bill. Please open the board. You take your process. How am I going to vote you? I'm going to vote you. Yes. Come on, he needs to ask questions. Oh. Who's got Subramanian?
Ayes 14, noes 1. I'm sorry, ayes 14, noes 0, abstentions 1.
Well, Senator Diggs, you're on the dance floor later this week.
I'm certainly pleased with a good start.
All right, you got one more, I think, right?
Yes, sir. Senate Bill 208.
All right. This, I think you want more people to be able to access juvenile records with fewer reasons, right?
Yes, sir.
Okay. Fire away.
Mr. Chairman, committee members, the intent of this bill is to allow the release of confidential juvenile records that are already released to several different agencies or organizations within the state to law enforcement, and it also provides for the notification of the release of a juvenile who has been detained or is in some kind of program to the victim. This provides, again, notification to the victims of a crime committed by a juvenile. It provides access to confidential records to full-time or part-time law enforcement officers who have the need for a juvenile offense history or for identifying a juvenile. The Constitution already provides that victims are accorded the rights of notice in the process, but it's only, as current law is only the victims of adult offenders can be notified for release from custody. Currently not allowing access to previous felony convictions means that initial charges that are sometimes secured could be changed or altered, and when the Commonwealth obtains this additional information, criminal histories, we then have to maybe go forth with additional or amended charges, and sometimes the youth may be arrested twice. This change would allow a streamline of the process and prevent youth from being subject to detention several times. Also, this is a pro-victims rights bill and allows victims to be notified when juvenile offenders have been released. Oftentimes, when imagine being in a mall and you think you've been the victim of some kind of assault or serious crime, and you see the person who that you've been victimized by, and it could certainly surprise you and maybe cause you great emotional distress. And we just think this would help victims and also help law enforcement officers do their job.
So, Senator Diggs, we normally have some very tight restrictions on who can access records when a juvenile is charged with a crime, and this basically opens it up to make it a lot easier for law enforcement and crime victims to access it. There's no standard in this, though, right? I mean, they don't have to show a need to access it. They just get to access it because they want to access it, right?
Not that I'm aware of, but there is, I believe, language in there saying, requiring that you have a necessity to do so. And I know that other parts of that, should you not use the information or when the information is no longer necessary, that it will be destroyed.
Mr.
All right.
Chair.
Who is that? Oh, Boysko. And I see some other people leaning into their mics. Go ahead, Boysko.
Thank you. Senator, isn't there already language in the code that says if there is a compelling interest that officers could have access to the records of the juvenile?
I certainly would like to defer, if I could.
Robert Tracy with the Attorney General's office. The bill would change that standard to a demonstrated need, and that's page 2 of 3 in 94, 95, and 96, to make obtaining this information a little bit easier to advance all of the goals that the Senator has articulated.
Okay. Senators down there leaning at your mics. Senator Carol Foy.
Thank you, Mr. Chairman. So the issue that I have with the bill is that on line 94, have a need is not defined. So it can be that the officer wants it, and that's it. I think we're very prescriptive about the information that we allow people to have access when we're talking about juveniles, and that's been recognized multiple times and for the many reasons. So I have serious concern about the fact that the have a need is a new standard. It's not defined, and I think it's overly broad.
Okay.
Mr. Chairman, if I may.
Senator Diggs.
Local law enforcement agencies would already have that information available to them if it had happened in their jurisdiction. What this allows us is to be able to easily access that kind of information from other jurisdictions in an effort to make this an easier process. And also there is the victim's notification.
Mr. Chair.
Senator Carol Foy. Oh, Perry.
If I could, maybe if we amended it and added some language about a need for criminal justice purposes, if we specify it, I can't imagine another reason that the sheriff's office or a member of the state police or police department or sheriff's office would need this information outside of for a criminal justice purpose, related purpose. So if Senator Carol Foy's concern is have a need, perhaps if we put that language in, that would help clarify.
I'll second that motion.
Senator Diggs, is that an amendment you're open to?
Yes, sir, as I understand it.
Okay, so just so we're clear, Senator Perry, you want to add it to where?
Mr. Chairman.
Yep.
I think we can add it to line 94, having a criminal justice need for juvenile offense history or identifying information, et cetera, et cetera.
Having a criminal justice need on line 94. Senator, Taylor or Mr. Benjamin, is criminal justice or criminal justice need, that term's not defined anywhere, and was it 16.1 we're in right now, right? Yeah. Ray?
Mr. Chair, I was trying to look if any of the other exceptions we have currently have a similar qualifier. I'm not seeing it in the code section we're in. I will check Title 16.1. Maybe Mr. Benjamin has follow-up, but I will check.
Mr. Chair.
Yes. Senator Boyce, go to this amendment. Yep.
I would just like us to go back and have somebody define what legitimate interest is in the code versus what we're trying to do here, because I think we've already got the protection and the ability for necessity if we need to get that information. If you could define what legitimate interest.
Are you talking about person with probably legitimate interest in the case? I know person with legitimate interest is defined in I believe, for child custody purposes somewhere in 16.1, but I think that's a different kind of legitimate interest than this legitimate interest. Yeah.
That's what I'm trying to get to, is it already protected in here?
Taylor, Mr. Benjamin, you got a reaction to Senator Boysko's question?
I don't think that adding the word legitimate does anything, Mr. Chairman.
Mr. Chair.
Yes, Senator Diggs.
I believe in other sections that this would be essentially more than likely accessing it through the means of a computer, and I think there is computer trespass, some law that would cover that about inappropriately accessing computer files. That it very well may taking a stab at this, but I think that may take care of the concerns that it's when you inappropriately access some computer files, that is considered computer trespass and is a criminal charge. And I know that certainly most agencies, when they, much like running license plates inappropriately or accessing other kinds of information that is confidential, that I would have to say every agency would take disciplinary action and maybe even terminate an employee who misused their authority.
I got it. So, yeah, Senator Peake, you got a question about this proposed motion by Senator Perry? Okay. So, I guess the motion before us is to add criminal justice to line, what was it, 94? Criminal justice need to line 94.
Mr. Chairman.
Yeah.
In terms of the law, the thing that occurs to me is things like sort of like Senator Diggs referenced, criminal justice needs, criminal justice purposes that we see in the ability to access NCIC, VSIN information, that sort of language. I'm not able to pull it up right now, but I do think it is an important amendment to the code section to protect juveniles and their information.
Got it. I think the concern is that criminal justice need is still kind of an eye of the beholder, kind of pretty broad thing in any event. So,
Mr. Chair.
Senator Peake,
Could we
to
take
that,
this,
speaking to the motion.
speak to the motion? Well, based on that motion, could we take this bill by for the day to let that language get worked out and put in to the bill?
We can. Yeah, we can do it for Wednesday. It's just.
It's going to be hell.
Yeah, I know. We're taking a lot of bills by for the day. Right now, by my count, we have 118 bills left. Not counting the ones that haven't come in this week. So, no, that's not allowed anymore.
I know, we have 21 bills.
So Senator Diggs, you want to go by for the day, see if you can try and work on it some?
Your pleasure, Mr. Chairman.
It's your bill. I don't think you're getting a good outcome today if you don't. So
Yes, sir.
And work with the city.
Okay. We don't have to vote that, do we, Mike? MJ? Okay. All those in favor of taking it by for the day, say aye. 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 All those opposed, no.
No.
Thank you, Mr. Chairman.
Okay. Okay. Senator Diggs, thank you you got a couple out. No, who's next? I got Senator Van Valkenburg and then Reeves. Welcome to the jungle.
Thank you, Mr. Chair. Mr. Chair, members of the committee, this is Senate Bill 123. So this is a bill about zero lot lines, and this issue was brought to my attention by the city of Richmond and a constituent who was trying to remedy a building code violation on her zero lot line property. Zero lot line is a residential property that comes up or sits against the home's property line, and because one side of the home structure is at the edge of the lot, the property has no room between the house and the boundary line. In most zero lot line homes, what I'm about to talk about is not an issue if it's past the 1900s because they have easements built into the home ownership. This is really about older neighborhoods, particularly in Richmond, Norfolk, Alexandria, where because the chain of ownership and because all the paperwork is muddy, that they don't have a right to an easement, and they can't make the improvements they need to make. And so what happened in this case was the person had a building code violation, and the person that was on their zero lot line wouldn't let them fix it. This put that person in a catch-22 because the city attorney, in the city has a building code violation that they need to enforce. The property owners not letting them fix it. And so typically, city attorney's officers will follow up. City attorney offices will follow up on these violations, and most of the time this works itself out because neighbors work together. In cases where they don't work together, oftentimes the city attorney can call the parties into court and have this hashed out there too. In very rare circumstances, there's just no fix in the code for when a neighbor refuses to allow the person access to make the fix that they need to make. This bill allows those property owners to petition the circuit court when needing to make improvements, repairs, or maintenance on their property when they can't make them without entering their neighbor's property and permission to enter their neighbor's property has been denied. They would have to disclose the dates, facts, licenses, and insured providers entering their property before the court would even grant said licensure to get access to their property. They would be liable for any damages they did to their neighbor's home, if they did make any, when they were making these fixes or improvements. This really only affects historic properties. And similar laws have been passed in South Carolina, Massachusetts, New York. There is a line amendment to clarify that people making these improvements would have to be licensed and insured on line 21. And so I would like to move that amendment at the proper time. It's line 21, introduced after what we would insert licensed and insured. Yep. Yes, sir.
Okay, it's been moved and seconded. We had licensed and insured service provider on line 21. Between what and service provider? All those in favor say aye. Aye. Anybody opposed? No.
So I'm sure there's going to be a bunch of questions. I'll just close by saying that this is a very small subset of homes that we're talking about and gets smaller over time. And it's just about when you need to make a fix to your house and you can't.
All right. And Senator Van Valkenburg, I think you and I mentioned this. I think it actually applies to more than historic neighborhoods. For example, I'm aware of scenarios where I have constituents fighting about trees leaning over property lines, and people they can only touch the tree from one side or the other, and they won't let them on to fix the tree. And it comes up in lots of situations more than that. So, Senator Obenstein, you had a question?
Related question. There's nothing in this that says that it just applies to zero lot line properties, is there? I mean, it could apply much more broadly.
I'm very agnostic on the language on this. If we can fix it to narrow it down, if that would appease people, and if it would make it fit to those very specific circumstances.
Yeah. So, Senator Valkenburg, what I'm sensing on both sides is some reticence about the lack of guardrails and clarity, and there's a lot of other different variables that go into this, like about notification and length and extending the license at all. I've also heard a suggestion that the Housing Commission might be a place that could take this up, vet it, figure it out, get the details in it. Does it have any attractiveness to you?
That's fine. As long as the goal is to fix that very direct problem that very infrequently happens.
And I see the Housing Commission Executive Director back there nodding her head like she'd love to look at this.
I'm fine with that. I'm fine with that.
Okay, yeah, Senator Boysko.
Senator Van Valkenburg, has anyone from VACO or VML talked to you about this bill? Do you know what their position is?
Not this year. This bill, we originally started working on this bill 2 years ago. We had conversations then. 2 years ago was a long time ago.
Okay. Senator Deeds, you're.
I move we carry the bill over and send it to refer it to the Housing Commission.
Second.
Okay, it's the motion be to carry it over to the 2025 session with a letter from the chairman asking the Housing Commission to take a look at this in the meantime. Okay.
Yeah.
All those in favor say aye. Aye. Oh, whoops, we got to record it. Sorry. Thanks, MJ. Keeping us on task or in compliance here. Saddam.
Proxy for Senator Salim.
There we go. Okay.
Thank you, Mr. Chair, members of the committee.
Ayes 15, no 0.
Thank you, Senator. Okay, next up we have Reeves, who has, I think, one technical quickie bill left, I think, right? Or do you have more than one?
I think I have two, Mr. Chairman.
You do. You have two left. Why don't we do the easy one first, 169, the wrap back.
Mr. Chairman, this is what the captain mentioned too. They had a cleanup that the FBI wouldn't accept the program unless we cleaned it up. So we passed an enabling language, as the captain mentioned last year. Wasn't up to guidelines. The technical changes recommended by the FBI. What those changes will do is strike portions of line 22 to 23. It allows Virginia to rapidly adjust to additions, deletions, and FBI notification events. And under existing law, the Department of State Police cannot add and clearly indicate notification events without requesting statutory authority. It also strikes lines 54 through 55. The FBI indicated that that phrase is associated with persons-based wrap-back notifications, that Virginia plans to use event-based notifications instead of person notifications. The FBI will not permit Virginia to use event-based notifications if the language remains in the Code of Virginia. So that's the second part of that. Then the change to line 49 is required by the FBI to operate our wrap-back system the current 30-day time period to remove persons after death or another event that requires the removal from the system exceeds the FBI guidelines has been shortened to 5 business days. Mr. Chairman, that's the changes to the wrap-back program, the bill as it is.
If I had this bill, I would just want to say wrap back as many times as possible. So, any questions for Senator Reeves on this bill to clean up the wrap back system? No? Okay. Is there any, I see the state police are in favor. Anybody else in favor or opposed? Does this have to go to finance? Yes. No? Okay. Okay, it's been moved to report the bill. Will please open the roll.
Ayes 15, no 0.
Great. Thank you. Senator Reeves.
Next, Mr. Chairman, I have SB 8. It has to do with notaries and oaths. When I first got to the General Assembly under the McDonnell administration, everything you did for a notary was still in paper form. So I carried a bill that modernized us and made it electronic available and makes it easier for applications. One of the last holdout things that you have to do as a notary is you still have to go, regardless of all the paperwork that's done electronically, you still have to go down, take a day, go to the clerk's office, swear an oath, and leave. And as a business owner, that's a lot of time. And my idea was simply that if you're a notary in good standing, you took an oath, you're still in that same standing, you've qualified for renewing your license, everything else. It just waives the fact that you have to go down and raise your right hand and swear another oath for something that you already swore an oath for. It's kind of redundancy in the program. So there is a line amendment that DLS caught, and if the clerk could read that to get us where we need to be.
Yes.
Okay. Line amendment being distributed. Sorry. Line amendment being distributed to everybody.
Mr. Chair, the line amendment begins on line 15 after online. We are essentially reinserting some of the already stricken language. So we are reinserting provided online applications contain electronic signatures authorized by the Uniform Electronic Transactions Act, and then the corresponding code sections.
Okay. Line amendments in front of us. Any questions about the line amendment? All those in favor? Or is there a motion to adopt the line amendment?
So moved.
Is there a second? Okay, it's moved and seconded. We adopt the line amendment. All those in favor say aye. Aye. Anybody opposed? No. Okay.
So, Mr. Chair.
Senator Deeds.
If I can understand, if you're applying for another term as notary, you don't have to appear before anybody to do anything. You just have to submit the application electronically.
Yes, sir, that's correct.
Okay, Mr. Chair.
Yeah.
Yeah, at a certain point when you are, of advanced years, and you're applying for a driver's license, the DMV has the ability to require you to take a new eye test, for example. Somebody could be 75 or 80 years old or 85 years old and apply to be re-upped as a notary, and they wouldn't have to appear before anybody. That couldn't be required of them under this bill.
No, sir. Mr. Chairman, no, that would not require me. However, in consultation with the Secretary of Commonwealth, Kelly G., we talked about some things. We don't have a bill for it this year, but we'll probably bring a bill next year to kind of address that issue. And then what do you do with folks who maybe aren't in compliance with their notary requirements, and how do you go about that process? But this just cleans it up for business folks like myself, so we're not having to take a day off to run to the courthouse to try to get to the clerk's office.
Senator
We're already
Reeves.
in good standing.
Senator Reeves, here's a question I had when I looked at this with staff last week, is that suppose for the sake of argument that I'm a notary and that before my license is up for renewal, I get convicted of a crime that would prohibit me from continuing to serve as a notary. When I go to do my new application, as part of that application process, do you have to certify that you're in compliance with the law, that you haven't been convicted of any new crimes, that you're still a Virginia resident, all those things? Because
Mr. Chairman, that's correct.
You do have to do that?
You do have to do that. When you, in that electronic signature, that's why that's important. You have to put all that history down.
Okay, and Senator, and so also if you lie and we make the amendments that you're proposing, are there consequences for lying still?
Mr. Chairman,
I've seen that happen too.
I don't know under the code section. Maybe Mr. Benjamin could tell us. I would assume it would. No idea. I couldn't tell you, Mr. Chairman. That's not part of this bill, but I don't.
Well, I understand you're trying to avoiding having to raise your right hand, but I just want to make sure there's a consequence if you lie. If you lie on your renewal application, Senator Obenshain.
Mr. Chairman, convenient but apropos question. Does the Secretary of the Commonwealth, are they enrolled in the wrap-back program? And would that address Mr. Chairman's concerns about subsequent convictions?
It would, if they're enrolled.
Are they?
Well, it hasn't come into effect. It doesn't come into effect till next year. But,
We're still working on that.
But do they run?
Mr. Chairman, I'm trying to remember. I've been a notary for almost 20-something years, and I think when I go for my renewal every 4 years, you sign under penalty of perjury or something that everything you've provided is the truth. Now, I do not know what the internal processes are for the Secretary of the Commonwealth to do that.
Okay, Senator Obenshain.
So, but all this does is you don't have to go to the clerk's office to take the oath. The clerk doesn't undertake any investigation anyway, do they?
Mr. Chairman, Senator Obenshain, no, they do not.
Is there any way that we could have an electronic oath?
You could make it as a declaration under the declaration statute instead of an oath. Yeah.
Oath is, Mr. Chairman.
Yeah.
But in the oath, the promise to abide by the law going forward, the declaration would be something different. I mean, and I remember, Senator Deeds would remember this too, that used to be the law that we could administer the oaths as members of the General Assembly and had all kinds of secretaries and paralegals from law firm coming and asking us to administer the oath for them. And I think Senator Norman had that amended because it was quite distracting.
Got it. So, Senator Reeves, I might have a floor amendment for you before we get there, but otherwise, I think it sounds like you're in pretty good shape. Is anybody in favor or opposed to this bill? Nope. Okay, is there a motion to report the bill? It does not need to go to finance. It's been moved and seconded that we report the bill. Please open the roll.
My apologies.
Aired. Anybody got aired?
Ayes 13, noes 1.
Okay, it's not showing on my screen. Okay. Okay.
Mr. Chairman, I'll check with the Secretary of the Commonwealth too on that question.
Right back.
And Senator Obenshain as well. Maybe
We all want to
we
say
can get
right back
electronic.
more.
Yeah. Thank you, Mr. Chairman.
Thank you. Okay, next up, we go to committee members, I think, next. So, let's see. Who wants to go first? On my list, I've got Peak.
Yes.
You want to repeal Senator Deeds' bill?
I've got a motion.
And Majority Leader Scott's bill.
Yeah.
Let's start with
38?
67.
Okay, 67.
Warm up for that.
The probation violation bill. And in all seriousness, back in 2020 and 2021, there was a movement to revise the criminal system and kind of cut down on incarcerations, and one of those was probation violations. And I understand what the thought process was, and I think our judges do. But I've been contacted by a number of judges more than Commonwealth attorneys, with their frustration of the technical violations. The first, they can't do anything. Second, 14 days. Third, the bigger part of that is some of these people are not reporting to probation. So they've had criminals, not clients, they've had criminals not report to probation for up to a year and a half. When they finally, so they're not complying with any requirements whatsoever. When they finally get in front of the judge a year and a half later, that's considered their first technical violation. So they've absconded for a year and a half. They come in, judge can do nothing to them. And so they can be out doing drugs, doing whatever, not getting monitored for anything, not paying restitution. So that is one of the bigger issues. If they don't report, that's a technical violation, no jail time. Of course, they've raised the issue of discretion, that they feel that their discretion has been taken away. And that's been an issue back and forth when we talk about mandatory minimums and things like that. So now what we have is, no mandatory, and they have no discretion as to how to address these probation violations. One of the issues, if they're on drugs and they've really deteriorated, they can't put them in jail, they can't make them do anything. At the most, for 3 violations, 30 days. And so they could be out on a tear, drug and fueled, induced rampage. They really can't do much. So this is coming from the judges, and it's the Henthorne case that came out of the Court of Appeals. The probation doesn't start until they report, and you've got a big delay in reporting. So this comes from judges who are actually having to deal with it. They're very frustrated.
Thank you, Senator Peak. I see a big line of people queued up to probably want to speak against it. Why don't we do in favor first?
I think I got a few who want to speak in front.
Yeah, I'm sure you do. All right. Attorney General supports the bill.
Robert Tracy from the Attorney General's office.
Actually, why don't we put a time limit on this one? So why don't we go like 5 and 5 minutes per side, in case anybody else wants to really get into it.
For the reasons Senator Peak articulated, this is putting judges in a position where they can't hold accountable people who are violating the terms of probation. They're often offending by testing positive for drugs. Many of those people without accountability are released in the community and are overdosing. This is something that the Attorney General's office supports, and as Senator Peak articulated, judges as well, because it current law undermines your ability to hold accountable defendants who violate terms of probation. So we urge your support for the bill. Thank you.
Thank you. Commonwealth attorneys.
Thank you, Mr. Chairman. I need to make very clear this: the Virginia Association of Commonwealth, Nathan Green, Commonwealth Attorney from the City of Williamsburg, James City County. Make it very clear, the Commonwealth Attorneys Association is not taking a position on this bill. I rise to speak in my own individual capacity as the Commonwealth Attorney in Williamsburg and James City County. My office uses probation as an alternative to incarceration whenever we can. We do not want to see anybody incarcerated for anything longer than is needed for public safety and for rehabilitation. And studies have shown that swift and appropriate consequences are an assistance to rehabilitation. To basically micromanage from afar what the judges and the probation officers are trying to handle up close is difficult. The fact that, as the senators pointed out, that a number of technical violations could be addressed at a first hearing and there be no consequence for that whatsoever, takes away the judge's and the probation officer's ability to handle that individual's rehabilitation more appropriately. We do support the small fix here, that there is some consequence. Again, it's very minimal, 14 days and 30 days, I believe is the numbers, but I would support this bill.
Thank you, Mr. Green. Next up.
Good morning, Chairman Marcus Elam, Corrections Operations Administrator and Legislative Liaison for the Department of Corrections. And we do also support this bill. And really it's looking at what you just heard previously in terms of accountability, as well as incentives to have our folks, probation officers, really be able to provide the resources timely and effectively, particularly looking at drug use. A good example of that is with our CCAP programs. We're having a hard time being able to utilize those beds. Those beds are effective, and they are a huge resource for alternatives to incarceration. So the ability to be able to timely and effectively address treatment and other resources with those folks that are on supervision with us is pretty considerable. So to be able to change this bill and have this bill changed in this way gives us another tool to be able to address all the needs that we can that are required while they're under supervised probation. Thank you.
Mr. Chairman, members of the committee, Josh Humphreys, Deputy Secretary of Public Safety. I'll just echo the comments of Mr. Green and the Department of Corrections that the administration supports the bill. I'll just also note that the number of absconders we have in the Commonwealth is almost 6,400, and we attribute some of that to the changes that were made a couple of years ago, but that is a growing problem we have here. Thank you.
Depends on what absconding means. Okay. Any other? Okay. Let's go over to opposition. Mr. Haywood.
Good morning, Brad Haywood with Justice Forward, Virginia, and I'm also the Chief Public Defender in Arlington County in the City of Falls Church. I think it's important, first of all, to get our bearings as to who this law applies to, the limits on the incarceration, who they apply to. So they don't apply to people who are, as I think the Senator described, out on a rampage. Someone on a rampage is committing new crimes. Those people, when they get violated, they come before a court and they go to jail. They still go to jail. They often go to jail for a very long time. We're talking about people who violate one of the 10 or 11, I think it's actually 10, enumerated technical violations. So they're technical rules of probation, things like showing up for meetings, taking drug screens, informing your probation officer when you're going to move, looking for employment or maintaining steady employment. Those are technical violations, and what this bill seeks to do is put people in jail just for one of those. Nobody's committing new crimes. Nobody is out there on a rampage. All they did was not show up for a meeting with their probation officer. There's no reason to do that. That's a pointless use of incarceration, and there's a reason we passed these reforms. Moreover, there was a lot of talk about absconding. Well, I'll tell you the most common. So let's think about an absconder. There's this concern that somebody who has been put on probation then leaves and just goes and does whatever they want, and that they're somehow harming the community. Well, if they're gone for 2 years and all they come back on is an absconding charge, what else has gone on in those 2 years? They haven't gotten in any trouble whatsoever. And what's the point of probation in the first place? The reason probation was created was as a remedial tool to keep people from getting in more trouble, to keep them from having contact with the criminal legal system. I often talk about clients like that as somebody who's kind of done probation their own way. Yes, it's frustrating to a judge because the judge's order wasn't followed, but they've accomplished all the rules of probation, all the purposes of probation. The only thing that hasn't happened is they haven't checked those little boxes, jumped through those hoops, as the law, I think, somewhat arbitrarily requires of them. So the law is working very well right now. I have personally not noticed any problems. The only problems, honestly, are judges applying it inconsistently because they want to avoid the requirements of the law. So we asked the committee to reject this bill. Thank you.
Who's next? ACLU.
Thank you, Mr. Chair. Members of the committee, Sean Winetta speaking on behalf of the ACLU of Virginia. For the reasons previously stated by Justice Ford of Virginia, we do oppose the bill. We believe that the appropriate sanctions and resources for judges and for the Department of Probation and Parole are already in the existing code, and we ask that you oppose the bill. Thank you.
Okay. Thank you. You got 2 minutes.
Good morning. Chuck Mayer representing Julian.
legal. We're a civil and human rights nonprofit. We oppose this bill for the reasons previously listed by Justice Forward and ACLU Virginia. Thank you for your time.
Thanks. All right. None of the other people standing in the back are going to speak, I guess.
They love the bill. Just to wrap it up, two things. What has happened is where probation officers used to give guys the benefit of the doubt on the first drug test, second drug test, they wouldn't bring them in. Now they're bringing them in on the first positive test because they know they have to get it over with and out of the way. And the other part is the judges are now sentencing on the higher end, or some. I've gotten reports that they just go ahead and, especially in these drug cases, they suspect there's going to be problems, so they're sentencing them on the higher end because they know they're not going to be able to revoke time for the first 3 offenses. So that's part of the practical effect of this. And so what we're doing is just allowing them to give 14 days and then 30. So it's just doing away with that first. You can't even smack their hand on that first violation.
Great.
That's all.
Thank you, Senator Peake. Any other discussion? Is there a motion?
To PBI.
Okay. It's been moved to report and seconded. Was there a substitute motion? I think I heard.
Move to PBI.
Second.
Okay, it's been moved and seconded that we PBI the bill. Clerk will open the roll.
Hold on, no, hold on. Peake wants to fix his vote. Yes. Having voted on the prevailing side, I ask that we reconsider.
Your vote will be noted in the system, sir. Ayes 11, excuse me, noes 4, or ayes 13, noes 2.
Right, MJ, you can just fix that, right?
Yes, sir.
Yeah,
It will be
All three
noted
of
in the
those.
system. Yes, sir.
Can't fix the video, but we can fix
Y'all are just making too many motions on me. I heard the motion to pass.
Hey, Senator
first.
Peake, can you hold on 1 second really quick? We've now been, by the way, I've noticed, joined by our pages. And I wanted to see if our pages could introduce themselves to the committee and to everybody who's out there in the crowd. Tell us what your name is and where you're from. You got a microphone there on your thing. See it? Pull it up. There you go.
I'm Tavesha Patel from Chester.
Welcome. Okay.
I'm Margaret Bartos from Fairfax County.
Best county in the world. Okay. Great. Well, thank you for joining us today. We appreciate all your help. Senator Peake, what do you got next?
Let's go with Senate Bill 38, the presumptions against bail. And we made an amendment to that. Did we get that out? We're changing line 34, number 1, same as Senator Obenchain had it last year. We're just putting the presumption against rape, robbery, and murder. And it's really to show, I think, the attitude of the Commonwealth of what we think about these serious violent offenses, because most of the judges are not going to let somebody who's charged with a violent crime out. But it's more, I think it does set the precedent. It sets the tone from the Commonwealth that if you commit a serious violent felony of rape, robbery, or murder, you are presumed not going to get bail. And just in case there are any judges out there who are unconvinced, I think this sets the message and sends the tone.
Great.
Sets the tone and sends the message.
Any questions for Senator Peake? No questions. Okay.
I'm sorry, Mr. Chairman.
Sorry?
I'm sorry, I have a question.
Senator Perry.
Senator Peake, I'm sorry, your amendment is to strike the language and strike an act of violence is defined in 1922-97.1, line 34, and replace it with just offenses related to rape, robbery, or murder. Is that correct?
That's correct. To put that there is still a presumption against bail for rape, robbery, and murder.
Senator Peake, I got a question. So, Senator Peake, have you ever heard of a magistrate not requiring a bond for somebody charged with rape or murder? Because we're not talking about the judges here. We're talking about the magistrates, right? It starts with the magistrates, and then it goes to the judges, I guess, after that.
I'm trying to think. I think I actually been defending a rape person who we had a bond hearing who was not being held at the time, but I'm not positive on that.
It might have been straight indicted, maybe, but Senator Obenchain.
I am looking at the website for the Rappahannock Regional Jail for somebody who was booked on December 21, 2023, on entering the home of a person with a protective order, rape, burglary, violation of protective order, stalking, vehicle theft, and violation of protective order. While there was bond imposed, it was $500. This is a very real problem, and this bail was imposed in this case, but so nominal as to be essentially without bail. And you know, there are courts around the Commonwealth. I mean, this one was just sent to me, and I know that these folks are being released without bail, and it's a big problem.
Mr. Chair.
Senator Peake.
Senator Overton, and obviously we had that situation in Alexandria, I think, right after this, where the gentleman was out on bail or bond for a serious offense and then committed murder. So it is a problem.
I think a judge released him, though, right?
Exactly.
I think a judge blessed that person not having bond, right?
Yeah, and if we have the presumption against it, then he might not would have. So it does occur. It is a serious situation. And in rape, robbery, and murder, a presumption against bond, which can be overcome, and they put on evidence to overcome it. So it leaves it to the judge's discretion, but it sends it out there to our judges. Somebody charged with a serious violent offense, you better be really, really sure that they need to be out before you let them out.
Okay. Any other questions for Senator Peake?
Okay.
Carol Foy.
Thank you, Mr. Chairman. Oh, there we go. Okay, so to this bill, I believe in judicial autonomy, and I believe that cases should be evaluated on a case-by-case basis. And one of the issues that I have with this is that it is handcuffing a lot of magistrates and judges when we have empowered them to make decisions. And actually, this is addressed under 19.2-120 in omissions of bail. There are a number of enumerated things that a judge can take into consideration, such as the nature and circumstances of the offense, the weight of the evidence, convictions of the accused. So there are these things that the person who is the trier of fact can take into consideration when determining whether or not a bond is appropriate. Sometimes you have questions of misidentification. I mean, there's a number of issues where it may not be just or justified to hold someone without bond. And this presumption makes that more likely than not, which I find very problematic. So I think we need to trust our judges. We need to have cases evaluated on a case-by-case basis. And I think that judges are empowered to do these things, and we have to allow them to do these things. So I will not be supporting this bill.
Mr. Chair, to respond to the question, it's a rebuttable presumption, and so the judge can take all those in. Now, the magistrate level, rape, robbery, murder, violent, they may hold them with the presumption against, but then they've got to get a rapid bond hearing.
Mr. Chair.
I keep trying to step away from this, and y'all keep asking me questions. I just want to let somebody else talk for a minute.
Oh, Perry, I'm sorry. I heard a voice.
We are the same person.
Yeah.
Senator Peake, I'll just say, I just want to be clear, and I know you said it already, but this is a rebuttable presumption. As far as I see it, this statute, and I've always seen it this way, is essentially creates a presumption against bond, but it's only in the most violent of offenses, not just rape, robbery, murder. Historically, it would include offenses like strangulation, which became a felony. The General Assembly made it a felony. It has not been a felony my entire prosecutorial career, but it became a felony because of the increased chances of lethality for a person after they have been strangled to lose their life. Certainly in Loudoun County, we had the Lola Brigadeau case, which was a strangulation case. The gentleman was released after this law was passed, and she was subsequently murdered, or is alleged to have been murdered. I believe that case is still pending. And so I will say that I think that this law, the presumption against bond, is certainly a red flag for the concerns that were raised by my my partner to my left, my Miss Senator Carol Foy, certainly if there are issues related to identity or other concerns related to that this person should not be held, those can always and have always been considered by the judge, because it is in fact a rebuttable presumption, things that this person should be let out on, but in my opinion is just a red flag to the judge. This is a very serious crime. Please take it very seriously and strongly consider before you release this person on bail. However, if you think they should be released on bail and there are terms and conditions that can keep the community safe and that can assure that this person will reappear for their next court hearing, then you can let them out. So I actually would support the bill with more in line with the way that it was previously, to include things like strangulation in particular, not just limited to rape, robbery, and murder, but we'll certainly consider the bill as is.
Wow, Mr. Chairman, so did you hear that? I think she wants
Just
me to make it tougher than it
What we typically
already
do is we typically do the patron presents, we ask questions, then we let the public go, and then we debate at the end. That's usually what we do. So we usually ask questions right now, but just.
But that was a brilliant statement.
Yeah. So why don't we take testimony? 5 in favor, 5 minutes in favor, 5 against. Set a timer on this. All right.
Good morning again, Mr. Chairman. Nathan Green, Commonwealth Attorney for the City of Williamsburg and James City County, here speaking on behalf of the Virginia Association of Commonwealth Attorneys. I guess it's a good thing that we're not putting larceny on there, because Senator Perry just stole all of my thunder. And so for the reasons that have been articulated by Senator Peake and by Senator Perry, the Commonwealth Attorneys Association does support this bill.
Okay. Attorney General, same lineup as usual.
Chairman, Robert Tracy, Attorney General's Office, we support the bill for the same reasons that have been articulated by Senator Peake and Mr. Green. Thank you.
Mr. Chairman, members of the committee, Josh Humphreys with the Governor's Office of Public Safety and Homeland Security. I'll echo the comments of the previous speakers and just also indicate that there was another case of Carla Dominguez where she was in her apartment in Alexandria. She was raped by her boyfriend, subsequently let out on bond, and then he came back and murdered her. But that would allege to have murdered her. But that is the kind of cases that we're talking about here. But appreciate the committee's time and hope you support the bill.
Anybody else in favor? Okay, let's reset. Opposed?
Hello, Chairman. Hello, everyone. My name is Maisie Osteen, and I'm an attorney for the Legal Aid Justice Center. And in that capacity, we're members of the Virginia Pretrial Justice Coalition, which is an organization of about 25 groups that go from the national experts in pretrial safety and surveillance to local reentry organizations to statewide advocacy organizations like Justice Forward, like ACLU, like Legal Aid Justice Center. We are opposed to this legislation and worked really hard with Senator Deeds in 2021 when this was repealed, and we're really proud of that work. I think particularly this is an issue of equity. People who can afford attorneys, that rebuttable presumption in the case where it should be applied might actually apply. That doesn't happen to over 80% of Virginians who are not represented at their first appearance, who are not represented in front of a magistrate. So this becomes an equity issue of who can afford that defense early, not just who is being held on bail. Thank you.
Mr. Chairman?
Senator McDougall.
I guess I've been practicing law for a long time, but I've not seen a whole bunch of people representing a client in front of the magistrate. How often do y'all think that happens, and is that something that public defenders' offices do or do not do?
I've done it a couple times.
A couple times.
Well, when I go to surrender a client, I'll go with them and call the magistrate before they go in front of them. Maybe he can answer.
Yeah, I'll tell you how often that happens. My office, we didn't even know that we could go into the magistrate's office until earlier this year, so we don't. We're not there. But our magistrates also pretty much hold anybody charged with a felony, so I don't think it would make a difference. But Brad Haywood again with Justice Forward Virginia. I do think it's important in these conversations because what happens is you have a law that makes sense for 99.99% of cases, but the opponents of criminal legal reform can always find that one bad anecdote to make people concerned about what is actually the right thing to do. And in this case, last year this came up, and it came up again this year, the Ibrahim Bouachi case in Alexandria. criteria, and being cited as an example of how presumptions, the repeal of presumptions was a bad idea. Well, guess what? That happened before presumptions against bail were repealed. It happened in the spring of 2020. And it happened because in that case, the gentleman was charged with sexual assault against his partner or his ex-girlfriend. He had been held in jail for 8 months. The pandemic started. The Commonwealth didn't even file a response to the request for bail. And they only lightly objected at the hearing. So that had nothing to do with the repeal of presumptions. With respect to the Loudon case, that was charged as strangulation and it was charged as misdemeanor assault before the individual bonded out. Again, I don't think this bill would impact that set of circumstances. What it would help, and I think as a practical matter, there are presumptions against bail still. We all know that as practicing attorneys. A lot of you here are practicing criminal defense attorneys. If you're charged with murder, everybody's presuming you're being held. I can think of only one person charged with murder that ever got bonded in a jurisdiction I practiced in, and that was James Christopher Johnson in Arlington. He was charged with a murder for hire that occurred 25 years ago. He went to trial a year and a half ago. He never had any other record. He was acquitted after 30 minutes by the jury. So somebody like that ought to be able to have a fair hearing because he didn't do anything wrong. And he could prove it to the court during his bond hearing. He could prove it to a jury during trial. So we'd ask the the committee to vote nay. Thank you.
Okay. 1 minute, 41 seconds left.
Hello, Mr. Chair, members of the committee, Dominique Martin, New Virginia Majority, and for all the reasons previously stated, we oppose the bill.
Good morning, Mr. Chair, members of the committee, Chuck Mayer, Julian Legal. For reasons previously stated, as well as the fact that we believe that magistrates and judges already recognize serious charges when they're placed before them, we oppose the bill. Thank you.
Great. ACLU.
Good morning, Sean Winona, speaking on behalf of the ACLU of Virginia. For the reasons previously stated, we also oppose the bill. If we need to train our magistrates and our judges better to evaluate these cases, we can, but we believe they have the appropriate discretion as currently written. Thank you.
All right. Thank you. Anybody else opposed? Okay. Senator Peake, you want to have the last word before we debate this some more?
It's a rebuttable presumption. I think more than anything, it sets the tone for the Commonwealth and sends a message to our magistrates and our judges for serious violent felonies. You better be really, really, really certain before you put them back out on the street.
Great. Okay, so any other discussion? Carol Foy, do you have a...
Yes.
Okay, Carol Foy for the debate.
Very briefly, I keep hearing the words rebuttable presumption, but we have to remember that rebuttable presumption, it effectually operates to remove the presumption of innocence that this person has, and they are charged now with, without the assistance of counsel at first appearance, to rebut this presumption. Oftentimes they need to put forth evidence. Well, they're likely arrested and incarcerated. So that's almost an impossibility. So I want to make sure that we don't treat rebuttable presumption if it's nothing. It is absolutely something. The burden has now shifted to the accused to prove that they are not a danger to themselves or the community and they are not a flight risk. And that is close to an impossibility given the restraints that this person now has, being incarcerated and under arrest, not having access to counsel at first appearance, or not having the money to hire an attorney to come represent them to rebut this presumption. So I will strongly ask this committee to not support this bill. And I again thank Senator Creed for bringing forth this legislation a few years ago to make sure we have a more just and fair criminal justice system. And this is one of the best ways we've been able to reduce mass incarceration here in Virginia.
Senator Obenshain.
Mr. Chairman, I think that Senator Peake offered an amendment that may not have been voted upon. And I would move the amendment. If we do not have language, I would move it in concept to apply to offenses related to rape, robbery, and murder.
Second.
Okay, so
It's in concept.
So you want to add, let's see, so right now it's an act of violence defined in 1992-297, life in prison.
It would conform to the bill I introduced last year if it helps.
Okay, It's moved and seconded, that line amendment in concept. Everybody understand it?
And Mr. Chair, I can kind of report it if that would help everyone. It would be, as you stated on line 34, striking an act of violence as defined in section 19.297.1, and instead listing aggravated first or second degree murder under Article 1 of Chapter 4, Title 18.2, robbery under subdivision B or B1 or 2, and rape, forcible sodomy, or object sexual penetration.
Got it. So that narrows it a lot.
Move that.
Okay. All those in favor say aye.
Aye.
Aye. Anybody opposed? Okay. All right. Do we need to vote that? Okay. Amendment's adopted. Okay. Is there a motion on the underlying bill?
Move to report as amended.
Substitute motion.
Mr. Chairman.
Is there, well, first let's try and get this in the right posture.
Substitute motion to PBI.
Okay. Okay. Is there discussion as to the motion, Senator Perry?
No, there's no discussion as to the motion. I was told earlier that the appropriate time to debate was at the end of the bill.
No, we can debate now. You can debate the motion. You can debate the motion.
To debate the bill,
Yeah, the motion to PBI, yeah.
I don't have any comment on PBI.
Let's vote.
Okay. Okay, clerk will open the roll.
Well, the motion is to PBI, correct?
Right.
So I don't like that one. I get it right this time. Senator Deeds is always trying to trick me.
Ayes 8, no 7.
Okay. PBI by 8-7.
All right.
Is that it for you?
Nope, Mr. Chairman. Senate Bill 77, also petty larcenies.
Oh, yeah.
After 3 or 4, and this is one that during the George Floyd issue and criminal justice reform that I've heard, these are all brought to me by judges and not judges in my jurisdiction, that they feel powerless after seeing people with multiple misdemeanors of petty larceny. They would like to be able to make it a felony and put a little more jail time on them. And you've seen what's happened across the country since the criminal justice reform. A lot of retailers in large cities with multiple shopliftings, a lot of Commonwealth's attorneys don't bother to prosecute them. And this just sends a message that in the Commonwealth, we will protect our retailers, we'll protect our grocery stores, we'll protect our small businesses, that we're not going to allow people to continue to commit petty larceny from you multiple times and it never be elevated to a felony.
So, Mr. Chairman, Senator Peake, the specific purpose of Senate Bill 77 is to undo legislation that we passed in 2021.
Exactly.
Okay, thank you very
Because
much.
of the disastrous effects we've seen across the country from that type of legislation.
Okay. Any other, nope. Any questions, Senator Peake? Create this new felony for petty larceny? No. Okay. Anybody in favor?
Me?
No, testifying in favor. No, you guys are in favor. Anybody opposed? Huh? Senator, was that a question? I'm in favor. Okay. I'm sure you are.
Just real quick, Brad Haywood again. Shoplifting actually hasn't really increased, and that's what we're learning over the past several months. Report after report is now clarifying that the retail industry actually was pumping up its own claims about an increase in shoplifting so as to deflect from the fact that brick and mortar retail is a failing industry. The best example actually was Walgreens. Walgreens announced that they were closing 200 stores, including stores in San Francisco, because they claimed shoplifting was on the rise. Well, in fact, they had planned those store closures 2 years before that because of slow sales in those industries or in those locations. I would add, as a criminal defense attorney of 20 years, I represented many people charged with the felony petty larceny, felony petty larceny. I can't remember a single one of them who was not unhoused or had serious mental illness. This was a law that essentially punished people who didn't have homes and who didn't have money. And I think that's something that we never really think about when it comes to stealing. Find me somebody who has money in their bank account, and I'll show you somebody who's never been charged with petty larceny before. The people who commit these crimes, especially over and over again, are those who don't have means,
Chairman.
and they need help. They don't need felony
Mr.
punishment.
Chairman.
Thank you.
Senator Obenchain,
Was there
question
not
for you.
a Washington Wizards basketball player who was charged with petty larceny in D.C. sometime over the past few months? Do they not have money?
Well, Your Honor, Senator, gosh, I don't know where I am today. Sorry. Usually at this time in the morning, I'm in a courtroom. So we can always find one anecdote. But when you talk about the hundreds of people I've represented, they're homeless people. That's just who was charged with this, and the data would undeniably support that contention. Thank you.
Okay. ACLU.
Good morning, Sean Winneto speaking on behalf of the ACLU of Virginia. I need to get at the front of this line, perhaps, because Mr. Haywood is basically taking all of our talking points for the same reasons we oppose the bill. Thank you.
Thank you. Okay. Anybody else? Nobody else. Okay. Senator
Nothing
Peake,
further.
last word.
Nothing further. Let's
Okay.
go.
Any further debate? Any motions?
Second.
That's all right. It has to go to finance if it gets out of here. Senator Deeds.
Substitute motion to PBI.
Okay, it's been moved and seconded. We PBI the bill.
Mr. Chairman.
And we further debate. Senator
Speaking
Obenchain.
to the bill. I know that some of the speakers stood up and without citing any sources have suggested that there's no increase in shoplifting. And I would challenge them to come forward with those sources because I'm looking right now at Fairfax police records indicating that between 2022 and 2023, there was a 41.7% increase in shoplifting in Fairfax County. It is easy to come up and speak at that podium with platitudes and vague statements with no support and holding that out as true. It is not true. And I just would ask in the future that if folks want to come and argue against a bill, that they make their argument based on facts and not what they wish those facts to be. This is a problem. And I would hope that we would at least give some consideration to passing this. But I get where folks are, irrespective of whether there's a problem or not. But I would submit that there is, and I would hope that members would support this bill.
Go for it.
Mr. Chairman.
Mr. Chair.
Senator Deeds and then Senator Perry.
Mr. Chair, I appreciate what Senator Obenchain says, but I'd be more interested in comparing the 2022 numbers to the 2023 numbers to the 2018, 2019 numbers. You did the
2023.
but pre-pandemic. I think the pandemic had a significant impact.
2022 to 2023.
I know.
Pandemic shadow. Senator Perry.
Mr. Chair, I would just say, at least in Loudoun County, I think maybe one of the issues also with these numbers is the fact that I am personally aware of several stores in Loudoun County that no longer attempt to prosecute these cases anymore because they have been dejected. They haven't been brought into the court. The Commonwealth Attorney's Office has been dropping them left, right, and center. So they literally stopped funding their loss prevention officers to pursue these at all. And I think that will always make it difficult to see actually what the numbers are. I am sympathetic to Mr. Haywood and his the report that he references, where it does appear that those numbers were overblown, and certainly that's not helpful to the conversation at all. But I am concerned about, and I have heard from members of my minority community that own smaller stores, and the uptick that they have colloquially seen in terms of thefts from their stores and the lack of the ability to do anything about it.
Any further discussion on the motion to PBI?
Mr. Chairman.
Senator McDougall.
Mr. Chairman, I want to echo what Senators Obenchain and Perry had articulated. I think there are other jurisdictions, including Virginia Beach, that have seen double-digit, almost 50% increases in shoplifting, and many of the stores, including ones in my area, have also made that choice not to prosecute shoplifting cases and articulate for their employees just to let people walk out of the store because they don't want to run any other liability risk as well. Shoplifting is a tremendous problem, and it does impact people who are financially less fortunate because it raises the cost on everything. That cost gets spread out to other customers that shop at that store. I would hope that we would give serious consideration to supporting this.
Mr. Chairman.
Senator Stewart.
Thank you, Mr.
Carried the
Chairman.
organized retail theft bill last year.
Well, I want to pile on with what the last three speakers have just said, but I mean, you kind of have to live under a rock not to realize that this isn't a big problem. It's on the news almost every other day. We now have retail stores closing regularly in areas that people really need those retail stores. And it is such a big problem that they just can no longer keep their doors open, and you're actually putting these folks that you're trying to help in a worse predicament by not holding the ones responsible accountable. So I hope we can pass this bill.
Thank you, Senator Stewart. So this is the great shoplifting debate. It's been going on the 14 years I've been here. But I would just note that I think that where we're coming apart here is the difference in comparing whether we're looking at data between 2020 and 2021 and today versus going back before that. And I think if you look at data from 2018, if you compare 2018 data to today, shoplifting is probably down. Although it's kind of hard to calculate in Virginia because of the changes to the threshold in terms of looking at petties versus grands, and we don't exactly have perfect data. But I think that's kind of what we're all arguing about here. But we've been fighting about this for 14 years. We're probably going to keep fighting about it, is my guess. Senator Obenchain, go ahead.
Back to my previous point, and I say this with great respect to my chairman, but the data does not reflect what Mr. Chairman suggests. And I'm just now looking at Virginia's or at national statistics, and shoplifting has increased from about $50 billion to $143 billion from 2018 to 2024 or 2023. So I just point that out.
Right. And I also have data showing it's down from 2018, and we can debate this a long time. So we have a motion to PBI in front of the committee. Any further discussion? Clerk will open the roll.
Ayes 8, no 7.
Bill is PBI'd. Thank you, Senator Peake.
Thank you, Mr. Chair.
Next up, we have Salim. One bill to go after this, I think. Senator Salim, your first bill.
Yes, sir. Mr. Chairman, the committee, I just want to bring up a bill, Senate Bill 332. The bill changes the maximum term of confinement from Class 1 misdemeanor in the Commonwealth of Virginia from 365 days to 364 days. And the reason for this is going to prevent lawfully admitted green card holders from being deported and potentially separated from their families over a minor criminal offense. Under the federal law, a lawfully admitted permanent residents can be deported if they're convinced or convicted of a crime of moral turpitude for which the maximum punishment available is 1 year or longer. So we are simply asking for this to be changed to 365 days to allow them to stay here. And just to ensure that there's a question about undocumented immigrants that do come up, this does not change anything in relation to that. Other section of the federal law makes those determination. And of course, aggravated felonies, controlled substance crime, firearm crimes, and crimes of domestic violence are all dealt with other code sections and would be grounds for deportation. So this does not impact that either. So I asked the committee to take up on this. And I do have some of the folks that are coming here to support this bill.
Okay, any questions for Senator Salim?
Mr. Chairman?
Senator McDougal, Perry, are you going?
I have not now and don't ever intend to do any immigration practice, but one of the questions I had, is a violation of a protective order considered a domestic violence offense under the immigration statute?
I think that's a question for the Fourth Circuit, the way that plays out. I think.
Well, Mr. Chairman, the reason I ask is because it was just articulated that this wouldn't affect any acts of domestic violence, and certainly a violation of protective order would fall into that in my mind. So that would be an important question to have answered.
Yep, I don't think it's statutory, though. I think it's case law, but I don't know what the answer is off the top of my head. Senator Salim, do you understand what he's asking you?
I don't, but I do know that some of the other immigration law, this law will not impact those.
Mr. Benjamin doesn't do immigration. My recollection is that whether it's class 1 misdemeanor or not, whether it's 12 months or not, a crime of violence gets you on the deportation list, regardless of whether it's 12 months or less. But I'm not an immigration lawyer, but that's my courthouse rumor understanding.
Mr. Chairman, as you know, a violation of protective order could be by an individual or third party. It could be communicating. It doesn't actually have to be a physical act of violence.
Right.
But it's one that could put the party in danger.
Could.
So we do not define it in Virginia statute in one of the list of acts of violence.
Okay. Any other questions for Senator Salim? Nope. Okay. Let's put a timer on it. 5 and 5. MJ, all those in favor?
If you're speaking to the bill, would you mind moving closer to the podium?
Yeah, so we can move quick. You don't lose time.
Yeah, thank you so much, Mr. Chairman and members of the committee. I'm Brianna Diaz. I'm with the ACLU of Virginia, and we support Senate Bill 332. Under federal immigration law, a state misdemeanor that carries a potential sentence of a year or more, 12 months or more, is treated as a felony for immigration purposes.
You might want to slow down.
You want me to slow down?
Yeah.
I'm trying to be respectful of the time. I will, sir. So this results in a devastating and unintended consequence that automatically strips immigrants, including green card holders and refugees, of their status and subjects them to mandatory deportation. A person need not even receive the full 365-day sentence to trigger this harsh penalty. Automatic deportation kicks in as long as the maximum allowable sentence is equal to a full year or more, even if the person's actual sentence was 20 days in jail or was completely suspended. However, this can be avoided by changing the penalty from 365 days to 364, so we ask that you support the bill. Thank you.
Good morning, Mr. Chair and members of the committee. Christian Martinez, I'm the Research and Policy Analyst at CASA. We support this bill. Some states that have passed this is Utah, Colorado, New York, Washington, Nevada. Recently, since you last heard this bill, Minnesota signed this bill into law. And so we thank the senator for bringing this back up. This bill passed the Senate last year, and so we hope for that continued support. Thank you.
Thank you, Mr. Chair, members of the committee. Dominic Martin, New Virginia Majority, and for the reasons previously stated, we also support the bill.
Good morning. My name is Alina Kilpatrick. I'm with the Legal Aid Justice Center. I am an immigration attorney there, and because you asked the question, Senator, the answer flew from my mind immediately as to whether or not the violation of a protective order is a crime of domestic violence under immigration law, but I can tell you that domestic violence definitely is, stalking definitely is, and I will actually send you my answer in writing to your office if you would like. But what this bill does not do, and I think this is very important for everyone to understand, immigration law, just like regular criminal law that we've been talking about all day, is very discretionary. Immigration judges have the discretion to grant asylum, to grant cancellation of removal. But that discretion is taken away from them if a person is convicted of a crime, of certain crimes, with a penalty of up to 365 days. It doesn't matter what their sentence was. This is not a sneaky poke to get around federal immigration law and to tell the federal government that we're not doing what they want us to do. This allows immigration judges to look at people and the totality of their circumstances and decide, okay, you stole. I don't want you to have asylum. It doesn't make it so that if someone has a theft crime and they are unhoused and poor, as many of our undocumented and asylum seekers are, it doesn't prohibit them from getting asylum. It allows the immigration judge to have their discretion. That's all this one day does. And for that reason, we are in support of this bill.
Mr. Chair, I've got one question, and Michael, I'd appreciate it if you stall the time. I got a email from somebody in support of this legislation that said the problem is that the federal law treats Class 1 misdemeanors such as shoplifting as crimes involving moral turpitude.
Correct.
Is that my understanding of Virginia case law is the state defines shoplifting as a crime of moral turpitude.
That is correct, but here's what federal law does that the state doesn't.
Okay.
It's a combination. So in order to trigger the prohibition, you have to have a crime of moral turpitude and be convicted of one that has a sentence of up to 365 days. So by turning back the clock to just having it 364 days, which just makes sense logically, why do we have a misdemeanor and a felony have both 365 days? A felony is 1 year and a misdemeanor is up to 1 year? That makes no sense. But anyway, to answer your question, Senator Deeds, the immigration trigger is the combination of the nature of the crime being one of theft plus the maximum possible sentence being 365 days.
Mr. Obenchain has a question. We leave the timer off.
So,
Paused.
and perhaps you could help me. I do want to understand this. So, does the 365-day rule apply to just people who are seeking asylum?
No.
Or is it to somebody with a permanent residency status?
It applies to many things. It can apply to someone seeking asylum. Getting permanent residency is discretionary. So yes, it does apply to that as well.
But if somebody has permanent resident status, it doesn't apply to that.
It does actually. It actually does. So there is something, it's immigration law is so complicated, but for those of you who I know have practiced criminal law as public defenders or indigent defenders or on the defense side, you know that going through that Padilla training can make your just mind explode. Mm-hmm. This is one of those things that would actually help bring that back a little bit. But yes, a person can lose their permanent residency by getting convicted of a crime involving moral turpitude. There is a petty offense exception, but if you get more than one within a period of 7 years after your green card, then the exception no longer exists.
Further question.
Senator Obenchain.
My understanding was that the purpose of this bill was to address what you consider to be the unfair situation where immigration officials are deprived of any discretion. And what you're telling me, if I understand you accurately, is if someone has permanent residency status, whether they're convicted of something with a 365-day sentence or not, the immigration officials are not deprived of discretion. They still have it, but they could lose their status. Is that correct?
Not exactly. And I'm sorry that this is so weird and complicated, but if someone is convicted of two crimes involving moral turpitude after they have received their lawful permanent residency, it's gone.
Twice, okay.
Correct.
Thank you.
Yes.
Mr. Chairman.
Thank you.
Senator McDougall.
So just to make sure, because you seem to be the one here who knows immigration more so than law than the rest of us.
Thank God.
If I heard you correctly, it has to be two things. One, a crime of moral turpitude, which would be lying, cheating, or stealing, and a penalty of 365 days, 1 year or more. Is that accurate?
Correct. So if you rolled it back to 364, then that trigger doesn't apply automatically. But with most things, it is still discretionary. A judge can still say, or an adjudicator can still say, even though this doesn't trigger a bar, I still want to deny you this benefit.
Mr. Chairman, then
Senator McDougall.
why are we not taking a more of a scalpel approach then and only applying this to things that are crimes of moral turpitude, which would be lying or cheating, stealing? Why are we also applying it to acts like violation of a protective order or assault and battery? Because those are DUIs, because those will be things that will be, if we make this change, will also be impacted.
It will, of course, all the crimes will be impacted in that they will have a maximum possible sentence of 364 days. But what this DUI is in a different category. Interestingly, DUI will make you a priority for deportation or removal if you are undocumented. But interestingly, at federal law, DUI does not make you inadmissible or deportable unless it's a DUI drugs, which is just one of those holes in immigration law. So this allows the federal government, the adjudicators who are seeing everybody's lives, all of the evidence before them, to decide whether or not they're going to grant a benefit or they're going to deport somebody. The way the law is now, it acts as a prohibition and takes a lot of that discretion away. And I hope that makes sense in a land that is very, very, very complicated for any of you who have taken the plunge into it. Thank you, Mr. Chairman.
Yep. Thank you for your clarification. We need people to know what they're talking about. Okay. Next up, and restart the timer thing.
Good morning, Mr. Chairman and members of the committee. My name is Monica Sarmiento. I'm here on behalf of the Virginia Coalition for Immigrant Rights, and on behalf of our 45 organizational members, many of that you just heard of. We fully support this bill. Thank you.
Thank you. Okay. Senator Peake.
Mr. Chairman, Mr. Benjamin, question. How long has our misdemeanor statute been 365 days or 12 months?
Forever.
Forever. And Mr. Chairman.
Senator Peake.
And Mr. Benjamin, do you know if that is consistent with how it's been in pretty much every other state in the United States?
Mr. Chairman, Senator Peake, no, I'm not.
Not familiar with those.
I don't know.
All right. Thank you.
Mr. Chairman.
Senator Perry, before we get to anybody opposed.
Yep.
I just have a question about how this impacts the Virginia sentencing guidelines. And I don't know if that should be directed to Mr. Benjamin or not, but it goes, the sentencing guidelines score misdemeanors according to the 365 days. And so if we go and change all of the misdemeanors and we make them 364 days, they would no longer be scored as Class 1 misdemeanors under the Virginia sentencing guidelines. That's my understanding of the guidelines. I'm certainly sympathetic as a prosecutor. I've amended cases from 365 days to 364 days to try to help and alleviate this issue, but I am concerned about unintended consequences, and I'm not sure if that question's for Senator Salim or not.
It's Mr. Benjamin. Couldn't that concern, first of all, I think that part of the guidelines is probably something the Sentencing Commission adopted as opposed to something that's in code. So couldn't, as part of this, we have an enactment clause that asks the Sentencing Commission to address this change in their guidelines if this were to be enacted?
Mr. Chairman, I think so.
Yeah.
Let me take this moment to say we'll do everything we can to provide additional information to the committee because it appears, I think that the committee does need further information before acting on this, and we're happy to help. It's the will of the committee, of course, but.
Okay. Why don't we get to anybody opposing it first? Is there anybody that opposes the bill that we passed last year out of the Senate?
We did.
Nobody opposed? Well, no, I'm not saying that. I'm talking about people testifying. Okay. So that leaves us to, is there a motion on the bill? I think, does this have to go to MJ, does that go to finance?
It does not.
You wanted to go back for the day?
Yeah.
Mr. Chairman, I don't know if this helps, but any criminal defense lawyer has got to be alert when there is an immigration issue. And by immigration issue, I mean simply this. A client or an accused is either a U.S. citizen or not. And if they are not, then virtually anything that happens in a criminal case could have immigration consequences. For example, what we have learned is that if you plead someone to a misdemeanor for whom there may be immigration consequences, that you should, if they plead to 12 months suspended, there's likely going to be an immigration consequence. But if you plead to 354 days or 11 months, 29 days, all of it suspended, then you're avoiding a consequence. This is an inartful answer to very technical questions, and I think we could at least provide some greater guidance to the committee. But I think that's what the bill is trying to address, is the practice of automatically pleading somebody to 12 months with 8 months suspended or 12 months with 12 months suspended.
Mr. Chairman.
Okay. I think there's a motion to take a vote for the day.
Yeah, can I speak to that?
Sure.
If it's going to go by for the day, one other thing, and we talked about this earlier as to whether this is a solution in search of a problem, I'd be interested in knowing the extent to which that 365-day rule is actually leading to deportations. So that would be helpful.
Okay. Is there any other motions?
Move to report.
Okay, it's been moved and seconded that we report the bill. It does not need to go to finance. Clerk will open the roll.
Ayes 8, no 7.
All right. Senator Salim, you got a hot one for your first bill on the floor.
Thank you.
Okay, Senator Perry, I think you've got our last bill today.
Although it doesn't seem like it, good morning still, Mr. Chairman and members of the committee. Today, I'm presenting Senate Bill 211. This bill is very similar to a House Bill 895. This bill is sort of a technical amendment, but it deals with specifically protective orders under 18.260.4. Those protective orders are commonly referred to as stalking protective orders, non-intimate partner protective orders, or dating relationship protective orders, because they don't include domestic partnerships. Current law provides that a violation of this section, so a violation of the stalking protective order, can be found, it's a venue issue for jurisdiction where the protective order was issued, in the county or city, or in the county or city where any act constituting the violation of the protective order occurred. I've seen this issue come up a couple different times as a prosecutor related to if I'm driving down the road between D.C. and Arlington, I receive a text message that's in violation of a protective order. Where was I when I received that text message? Was I in D.C.? Was I in Arlington? But if I live in Arlington, then we know that we can proceed with a violation of that protective order there. It gives us certainty on venue. I saw that several times. We often don't know. We also could proceed under the theory of where the person was who sent me the text message, but that's often much harder to find. We would have to track that person down. We'd have to interview them or interrogate them, and they, of course, have Fifth Amendment rights. I will say that was not the particular impetus for this bill, though. The impetus for the bill was a woman who was on active duty military, and Delegate Bennett Parker was the one who asked me if I would carry this bill, and her constituent had a protective order that was issued in another state, and had, I believe it was mail that was being sent to her, and the Alexandria Commonwealth's attorney, Brian Porter, indicated that he had concerns based on the language of the bill whether or not he could prosecute that venue in Alexandria at all. This bill was put together with the help of the Virginia Association of the Commonwealth's Attorney, VACA, who I believe is here or was here, the Virginia Sexual and Domestic Violence Action Alliance, and they both support the bill. The small technical differences between my bill and H. Bill 895 is the addition of the word town in as it relates to the jurisdictions where the offense could have occurred.
Mr. Chairman.
Senator McDougal.
I'm happy to take questions.
Just want to make sure I'm following. So if a person lives in Arlington, they go and court grants a protective order, and then the places under current law that where the protective order violation could be prosecuted would be Arlington and where any violation occurred.
I think, sorry, Chairman and Senator McDougal, I think the answer is currently the current law says that a violation may be prosecuted in the jurisdiction where the protective order is issued. So, for instance, if I lived in Arlington, but my protective order came out of Alexandria, then currently, and I received a text message that was in violation of the statute in Fairfax, right? This adds that not only could this violation be pursued in Alexandria and Fairfax, it could also be pursued in Arlington because I live there.
Mr. Chairman.
Senator McDougal.
So, and then if the person, because the protective orders can be issued for up to 2 years, decides to move to another jurisdiction like Smith or Wise, then this could also be prosecuted in that jurisdiction, even though the defendant had never had any contact with that jurisdiction?
Chairman and Senator McDougal, the answer to that question is yes. And I'll tell Senator McDougal that this tracks with the language for where you can go and get a protective order. So, for instance, if there was someone and I was going to seek a protective order against them, although they may have never lived in Clark County, but that happens to be where I live, then I could still get a protective order in Clark County, although the person for whom the protective order was sought against has never been to Clark County, has never lived there, has never even, sought any offenses against or created any offenses, whatever the harm was, the threat in that county where I live. So this would seek to mirror that language. Again, going back to the woman who was here on active duty, the person who was targeting her did not live in the jurisdiction where she lived, but those offenses were happening there nonetheless, and so this permitted would permit a prosecution under this section.
Senator Perry, just so I'm clear, when I went over this with staff last week, council, correct? Thank you, Senator. When I went over with council last week, we cannot confer personal jurisdiction over anybody. So it's just not something we're constitutionally able to do. So we're not talking about creating jurisdiction here. We're solely talking about venue. So these are people that the Commonwealth of Virginia would already have the state would have jurisdiction over. So we're mainly talking about choosing venues within the state with this change, right?
That's correct, Chairman.
So by making this change, we're not sort of pulling somebody who's never been to Virginia into Virginia. We're just talking about people in Virginia. Tazewell versus Arlington or something like that. Yeah. Right. Okay. It could be if they met the personal jurisdiction statute. So, okay. All right. Any other questions for Senator Perry? Okay. Is there anybody here in favor of the bill? Mr. Green, in some capacity.
Yes, this is in the capacity of speaking on behalf of the Virginia Association of Commonwealth Attorneys. We are in support of the bill. There are the issues that the senator has identified. mostly with individuals with out-of-state protective orders. If it's issued in Fairfax or if it's issued in Arlington, then it's easier to go back to those jurisdictions. But if it's issued out of state, but they are being stalked or they are being harassed in between work and home, and so therefore the Commonwealth Attorney can't establish where exactly the text message was received, we have a problem. This would cure that problem and say you can go to Arlington if that's where you live.
Mr. Chairman,
Senator Obenshain.
Isn't this essentially what we did last year with financial exploitation of elders?
Mr. Chairman, Senator Obenshain, this is exactly what we did.
Yeah.
Mr. Grant, I have a question for you. So I had a scenario that just came to my attention where somebody out of the country had things directed at them, or somebody from out of the country was directing something in Virginia at somebody. Is that enough to confer personal jurisdiction?
No, Your Honor. Mr. Chairman, the answer to that, you could take out the charge if there is a protective order that's in place. If there's a protective order and they go outside of Virginia or even outside of the country, a warrant could be issued, but you cannot go and get them and bring them in and make them face that warrant. If they were ever to set foot back in Virginia, then there would be a warrant waiting for them.
Okay. Anybody else in favor? Nobody else out there? Is there anybody opposed to the bill testify in opposition?
Mr. Chair.
Second.
So was there more comment? Did I hear? Oh,
Mr. Chair, I just
Taylor.
wanted to bring something up for the committee to consider, and you may not want to. I just wanted to bring up that you might want to think about adding the same provision to the violation of family abuse protective order section. There may be reasons not to, but right now the venue provisions for both track the same, so you might want to provide this additional venue in that section as well.
Yes, ma'am. I took a look at that, and I have the same thought. I believe in my conversation with Delegate Bennett Parker, someone else is carrying that bill. But if for whatever reason it doesn't happen or it doesn't make it across, I'm happy to carry it next year.
Or we could just fix it right now. Because, some people like bill limits in my caucus. Does anybody want to make that motion that we conform the two protective order statutes?
So moved. And that's 16.1, 253.2.
Okay. It's been moved and seconded. We conform the two PO statutes. All those in favor say aye. Aye. Anybody opposed? No. Okay. Having said that, was there a motion? I heard
to report.
Second.
It's motion to report. It's been seconded. Clerk will open the roll.
Ayes 15, no 0.
All right, you're on the dance floor. And committee members, that's 108 bills to go, plus whatever's introduced this week. So I'm glad we got through that. I thought we were going to get done earlier today, but we got a hot committee today. So thanks for your time. We're adjourned.
Good job, Scott.
Thanks.
The Senate of Virginia, Richmond, Virginia.